task force called to order on Wednesday, September 3rd at 4:07. Mr. Young, would you call the roll, please?
On the call of the roll,
Hey, listen, I gotta go. I'll talk to you later.
Member Rummold. Rummold present. Member Winston. Winston did inform me that he would not be able to make tonight's meeting. Member Wolf.
Present.
Wolf present. Member Pilpil.
Present.
Pilpil present. Member Hepner. Hepner absent. Member David.
Present.
David present. Member Fisher.
Present.
Fisher present. Member Oka.
Present.
Oka present. Vice Chair Hyland. Hyland absent. Chair Washburn.
Present.
Washburn present. We have a quorum.
All right, at this time, we have some possible agenda changes.
I believe that item number 9, Ms. Johnston is here to possibly speak on the item. I don't know if you want to hear from her before you make that decision.
All right,
Hey.
there is some desire on the part of the task force to continue this, but we understand that you are leaving your position, and nevertheless, you have something to say on the matter. We also understand that you may have a written document that you'll give us at a later date. All right. So at this time, it's not my preference to take items out of order, given that other people are here for their matters. But I wanted to let you know that if you would like to speak, we want to give you that opportunity. But I'd really rather not move the item up. If you certainly.
Who is?
I certainly appreciate your willingness to accommodate, and if I could just understand, I'd be happy to submit something in writing as well if this matter will be continued, and my comments could be reserved for a written format if that would be something that the task. I'm not entirely sure what's going to happen when item number 9 is called, so that's why I'm not sure how to respond.
All right. So as I said, this item we put this on the agenda because there were some very interesting issues that came about from this case. So would not be a hearing. There'll be no facts and evidence. It's really a discussion to clarify in our minds some of the issues, and Member Rummold has written an extensive memo, and we would invite him to summarize and sort of educate us about it. So, and we'd like some more time for us to review the memo, get our thoughts in order for him. So that was our reason for wanting to continue, and I understood the police department also wanted to do it as well, but you wanted to be here because you're leaving your position. So
That's right.
if it would be okay for you to submit something in writing for us that we would have that we could spend some time looking at for when we do take it up.
Certainly. So there will not be discussion this evening, substantive. That'll take place later, so I can reserve my comments. Is that?
For writing, right.
Okay.
Unless
okay.
yeah.
Okay. Thank you.
You're welcome.
Madam Chair?
Member Pilpel, yes?
So I had a question about both item 9 and item 7. Item 9 is set up as a hearing regarding peace officer confidentiality. I did not understand from our July hearing on the merits of the Frank Lee versus Civil Service matter. I thought that we continued that for this discussion, but I see this is calendared as a separate file and just a hearing. So I don't know. Obviously, Ms. Johnston found out about it. I don't know if Frank Lee, the underlying complainant, was notified, and I guess I just don't really understand why this was set as a separate item and not just a continued hearing of the original complaint.
Because the hearing, that matter was concluded, if I recall it properly. The original case was concluded. There were some issues that arose. Member Rummold said he would brief us about the issues, and we would, for our own education and education of members of the public, we would put this on the agenda. So that's why it's there. It's not a hearing. would not expect to hear from the complainant. It no longer is specific to that case. It is something different.
Okay, then that's not my complete recollection of the matter, and the memo does address the facts in that particular case. So it seemed to me that we had not acted. We certainly didn't find a violation, but I thought we continued the entire matter. Maybe I'm...
Member Rummold?
That was also my understanding too, is that we were just kind of taking it under submission and then
Right.
going to reach a decision at a later date after we had the opportunity to kind of mull over the various issues.
So that's why I thought that the complainant also should be notified and might have views on this question of whether hearings should be open at civil service, et cetera, et cetera. I mean, that was the substance of the complaint.
Okay, that's not my recollection. I would have to look back at the minutes. Victor, what
This
is your...
I believe that the file 13091, that was continued to the call of the chair, pending the introduction of new information. However, the intention of tonight's meeting was not to hear the case 13091. It is to review the policy issue in general
Okay,
of police officer confidentiality.
all right.
So I guess when we get back to that item, my interest would be in having, a brief discussion, but continuing or just collapsing this file back into the other and assuring that both parties will be notified and that we can dispose of the original matter at an appropriate time. Anyway, I'm just laying out, that's where I was going with that. And the other concern I had was with item 7, the referral from the Ethics Commission. The packet material did not indicate if the parties were notified, and if we're going to have a substantive discussion on that, I wanted to be sure that both the complainant and the respondent were notified and had an opportunity to appear or present information.
Both parties were informed. Both parties were informed of today's hearing, but they were informed that they were not required to attend today's meeting because at discussion today it is the discussion of the Ethics Commission referral and not the merits of the case at this time.
So the question before us on item 7 is how further to proceed based on the referral back? Is that it?
Exactly. So we're not going to be hearing anything new. This is an item that's complicated. It's also very important. I'll have more to say about it later. I listened to 2.5 hours of the Ethics Commission hearing, and I think it's worth listening to for all kinds of reasons. But no, this is not at all to re-adjudicate this matter. It's for us to figure out what to do next.
Okay. I guess then my request is for things like both items 7 and 9, where it's not exactly clear what the task force's intent is to make that more clear in the agenda, because it wasn't obvious to me reading the agenda or the materials where we were going with those.
Okay.
So, and I think that would help the public. I'm done.
Duly noted. All right.
Item number 2. Item number 2, file number 14031, complaint filed by Sophia Deanda against the Department of Public Health for allegedly violating Sunshine Ordinance Section 67.21 for failure to adequately respond to a request for records dated March 5th, 2014.
Is the complainant here? Ms. Deanza?
And
Deanda. Mr. Young, have you heard anything from her?
I have not. She was informed of the meeting. I did trade several emails with her concerning today's meeting, so she was aware of today's meeting date.
And there is somebody here from the Department of Public Health? Yes. Okay.
perhaps since we made an ADA accommodation and that's here and happening, maybe we could take the next item and see if Ms. Deanda appears.
Members?
I don't have a better idea.
Hear the next item and give the complainant some more time to come to
Yes.
appear? All right,
Yes.
that makes
Let's do
sense.
that.
Next on the agenda is item number 4, file number 14056, complaint filed by Jason Grant Garza against Ross Mergarimi, Paul Miyamoto, Kathy Gorwood, and Raymond Winters, Office of the Sheriff, and Eileen Shields, Barbara Garcia, and Faye de Guzman, Department of Public Health, for allegedly violating Sunshine Ordinance Section 67.21, 67.25, 67.26, and 67.27 for failure to respond to immediate disclosure requests in a timely and complete manner dated January 15, 2014.
All right, so I see that the complainant is here. I'm sorry. And,
Go from the Sheriff's Department in response.
all right, there were some other complainants or some other respondents mentioned. We have the Sheriff's Department, so the Sheriff's Department
Is present.
is present. Is there someone here from the Department of Public Health?
Yes.
Okay, all right. Okay, the first thing we must do is determine jurisdiction in this matter. Is jurisdiction being contested by either the Sheriff's Department or the Department of Public Health?
On behalf of the Sheriff's Department.
All right.
Could I?
Member Pilpel?
I was just going to suggest finding jurisdiction, and I would so move, but excluding Eileen Shields, who is retired from the city and, in fact, was not in that capacity at the time of the request. I think Barbara Garcia and Faye de Guzman are still covered, but I don't think Eileen Shields is relevant to this particular matter.
Second that.
Is there any objection to that? Okay. Is there a second to find jurisdiction?
I think we have a
Okay.
second.
All right. Public comment on jurisdiction in this matter?
I'm Patrick Manetzaw. I'm here on my own time. I'm not sure when the complaint committee or complaint subcommittee is being reconstituted, but I think it's high time that the task force put its foot down. There's a huge difference between public records and medical records, or public records and police records that may have involved medical records. And I strongly urge you to introduce a friendly amendment to this motion, and instead of accepting jurisdiction today, simply refer to your complaint committee to have an adequate discussion about jurisdiction of medical records, which are private records. They are not public records. You have been through this before with Mr. Grant Garza, and I believe the last time Department of Public Health's response to the complaint indicated that they are not public records. And so I don't believe you should even be wasting your time and screwing up your efficiency rating by hearing a matter that may involve public records. I mean, private medical records rather than personal records. This is not the Ministry of Information for private medical records. It's the Sunshine Task Force that deals with open government and open public records with the emphasis on public. I think you have granted far too much leeway to Mr. Grant Garza when former member Bruce Wolf tried to assist Mr. Garza. Mr. Garza's response was to bite back at the hand that fed him. It's now time for you to start exercising some control over your agenda. And if it is not a matter involving public records, you should not be wasting your committee time dancing around the issue anymore. Thank you.
Thank you. Is there additional public comment on jurisdiction? Okay, seeing none of
Through the chair.
Member David.
Yes. Is there a time limit on public comment on jurisdiction?
I haven't set one, no.
Okay, and I'm also going to request that the chair ask the public to keep the comments on jurisdiction to actually jurisdiction and not the facts of the case.
All right, duly noted. Without objection, the motion to accept jurisdiction. All right. For the hearing, now the complainant has up to 5 minutes to present facts and evidence in support of your complaint. We'll then hear from the parties who will have 5 minutes each, up to 5 minutes each to present facts and evidence. And
Before we start the talk, is it possible for me to request the overhead projector and the ability to use the screen to show you a small clip of a video that I have when this incident occurred?
You may use the overhead projector. In terms of video, I do not know what format you have available to display at this time.
Windows Media.
If you have a file to upload to the computer, we'd be happy to do that.
Upload, or I can't install my USB drive and just, click to it and click to the section?
Mr. Garza, I'm unaware of what format you have. We can give it a try, but
Thank you. Let's do that. And then we can start the clock because, this is all part of my presentation.
oh, right, yeah.
Good to have you back.
GH illegal arrest.
I did. I have another black bag. I'll be okay.
Hear about the case sometime? Maybe that's too much to ask. Never mind.
Patience is a virtue. As my 5th grade teacher used to say.
Part of the Ministry of Sunshine,
Ladies of the
State 1127, back to medical records to give them this IDR, written request for my medical. A right of box. Coming out. Hello, is anyone? All right, so I'm ready to start now, if that's okay. All right.
time is starting now.
Yes, please. Okay, so this case is about an illegal arrest that I had at San Francisco General on 11/27/13. I was in there to give them an IDR to follow up for an illegal 5150 that I had requested my medical records for. Before I start the video to show everybody what happened and everything else, I want to point out on the overhead projector, and I don't know how to flip to it, the fact that, I've been in front of the task force many times, and the decision is that, yes, medical records are public records because they fall under the definition of public records, which I would have to find for you, but prior orders of determination ruling that one's own medical records. So I don't know how to get this overhead projector started. Well, then let's roll the film until I can get the overhead projector started. Just go ahead and roll the film then. Is anybody coming out to help me, or is everybody going to continue to hide behind closed doors? So here I am requesting my medical records. I'm trying to hand him an IDR. I'm in the public area. It's a hand-delivered immediate disclosure request. Do I give it to you, sir? Since you're calling security? No. Thank you for taking it. Please give it to Mr. Katzenberger. Thank you. Yes, please. Yes, please. And now that you have it in your hand, please give that to Mr. Katzenberger. Oops, let's drop it. Thank you, not my problem. Just goes to show you how much sunshine doesn't matter to the San Francisco General Hospital. Am I breaking the law? Can you quote me the law I'm breaking? Can you quote me the law I'm breaking? Don't approach me. Ask me before you... No? Are you not... Okay, so, this comment about, medical records, one's own medical records are public records. It falls in the same vein as, if you're requesting your police records. This assertion that they're not is just an inaccurate assertion. Now, on the overhead projector, for example, there's an order of determination dated 2011, December, in which the Department of Public Health ignores sending me my medical records, a copy of his medical records. So apparently, there's been a decision ruled in my favor that medical records are in your jurisdiction. Interesting. Another problem I have with your guys' dysfunction is that there's no precedent here. Yes, people are correct. I've been here numerous times regarding this issue over numerous years, only to have the Department of Public Health and everybody else play this game that, medical records are not public records. Each and every time, when I've won, there's been no result. As a matter of fact, here's another case in May of 2011 regarding the Haight-Ashbury, in which I was proven correct about a HIPAA violation, when I requested my medical records, and you guys found in my favor that, yes, medical records were public records. Shall I continue? Why not? Just to continue to show the farce here. Here is an order of determination dated 2002 against, mind you, the Sheriff's Department when it came to requesting my records, which included my medical records and everything, which you guys found in my favor. But, considering you never have a precedent set, and the wheel has got to continually be remade here, it's very, very harmful. Is that 117 that I have left, or 115 that I'm into this?
1 minute and 10 seconds left.
Oh my God. Anyway, I'm sorry about this. Basically, I've not received my records, what I requested through the IDRs, and, this is nothing more than a joke and a farce. It's continued. There's never, like I said, any precedent. There's never holding anybody accountable. The last time somebody didn't show up from the Department of Public Health, which was Miss Eileen Shields, she was referred to ethics. Nothing came of that. I have that determination. You guys are pitiful, disgusting, harmful, injurious to people who are trying to get their rights, what they need, so that if they need to file a lawsuit or do something proper, they can have their records. You guys are disgraceful. Totally disgraceful. Now, I'm sure that the other side is going to get up and tell you that medical records aren't. Look under the definition of what public records are. I believe it's 6252. Before you bend over backwards for the other side and their mischaracterizations and their misapplication of law.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant? Seeing none, let's first hear from the Sheriff's Department. And you'll have up to 5 minutes. Could you identify yourself, please?
Yes, thank you. Good afternoon. I'm Mark Nico, and ICCO here representing the Sheriff's Department from San Francisco. My understanding for this hearing was noncompliance with the public records request from the Sheriff's Department. As far as I can tell, there's been no proof and no evidence shown that the Sheriff's Department has not been completely responsive, both in the materials that were obtained for Mr. Garza and in the timeliness in which they were presented to Mr. Garza. We received a public records request for any information we had with respect to his detention on 11/27 of 13. As I submitted to the task force, we received that on January 15th. On June 16th, I responded to Mr. Garza within the 24 hours, indicating I was going to get those records that we had in our possession. On the 17th, I learned that some of the records are not readily available because they are in different places within our department and possibly in other departments I was assisting him to get the records for. Once I learned where the records were and what was available, I informed him of that on January 17th. The next thing I heard and the next thing I learned was on January 23rd, within the 10 days I told him I would be able to respond to him by. I received and forwarded to him an incident report from San Francisco General Hospital regarding his detention. The day after that, I received a UNEP log, further information that he requested, again from San Francisco General Hospital. That was all the Sheriff's Department had in their possession that was responsive to this request. Therefore, he did receive all information from the Sheriff's Department in a timely manner. I additionally informed him that San Francisco General Hospital was the keeper of any video that might be available, and he should continue to contact them for response to that part of the request. My understanding is, and I shared that with him, that video was not available, but again, that was just in being compliant with his request. We didn't have access to it, but I informed him of what I knew and where he could go to look for that answer. Therefore, I don't believe that there is any substance to the complaint in front of this commission or task force to substantiate that the Sheriff's Department was anything but timely and responsive to his request.
Thank you. Is there anyone here to offer facts and evidence in support of the respondent, in this case, the Sheriff's Department? All right. At this time, is there someone here to represent the Department of Public Health?
Brian?
Nancy Soraya here on behalf of the Department of Public Health from the Public Information Office. This is regarding the same request the Sheriff's Department received on January 15th, and the Department of Public Health responded the next day on the 16th, invoking an extension of time until we could respond to Mr. Garza's request. On January 28th, we responded, letting him know that the video footage that he was requesting was not available because it falls under the jurisdiction and management of the Sheriff's Department, as far as we knew, and we had no records responsive to the request.
Do you have anything additional to say?
That's about it.
All right. Is there anyone here to offer facts and evidence in support of the Department of Public Health? Okay, seeing none, the matter's with the members of the task force for questions of the parties. Member Fisher.
I'm sorry, I didn't get your name. Department of Public Health?
Ms. Soraya?
Ms. Soraya and Mr. Nico.
Yes.
Yeah, both of you. I'm a little confused, which happens quite often, so it's not on you. Mr. Nico, you said that you referred Mr. Garza to the Department of Public Health, and then I heard you say you referred him to the Sheriff's Office. Maybe the both of you go one step further and explain that to me? Because it seems like he just got batted back and forth like a ping pong ball.
My understanding from our institutional patrol enforcement out at San Francisco General Hospital is they do not take care, they do not monitor or have the video equipment at the hospital, therefore they were not in control of the video. I advised Mr. Garza that San Francisco General should be the person or the party who he should request that from. They were already named in the request, so I knew he was already dealing with them.
And then Ms.
Soraya.
Soraya, I'm sorry, Soraya.
Go ahead.
All I heard you say was, we don't have it either?
Right.
Or-
So
or
Our understanding is that security and the cameras fall under security at San Francisco General, so that's under the Sheriff's Department. However, I did receive a response from our facilities department at San Francisco General Hospital saying that they did not, there was no video from that day for some reason or another. I didn't get the reason behind that, so that's, I'm sorry, I can't be more clear on that.
Okay, I mean, what comes up a lot is, does it exist or does it not exist?
Right.
And, as part of the ordinance, we can't compel you to create something that doesn't exist.
Correct.
Perhaps Chair Washburn has someone else that has something to say.
Member Wolf.
Ms. Soraya, so I just want to kind of go through how the video, the San Francisco General Hospital, the entity that manages that is the Department of Public Health, is that?
Yes.
Okay. And then the security of SF General Hospital is both a security department and the sheriff, or just the sheriff's department?
Solely the Sheriff's Department.
So all security is handled by the sheriff's department?
Correct.
And the video surveillance within the hospital is handled by the security, which is the sheriff's department, is what you're saying?
I am not sure about that.
So you said you contacted someone at facilities.
Correct.
Who spoke about video surveillance.
Mm-hmm.
The person within facilities is not part of the sheriff's department.
No, they're with our department, the Department of Public Health.
So it's unclear whether the management of the video cameras in SF General Hospital are the purview of your facilities or the sheriff's department. And the sheriff's department has indicated that it is not their purview. Is it Mr. Nico?
That's correct.
Mr. Nico, the question, the filming at San Francisco General Hospital, is that under the administration of the Sheriff's Department?
I do not believe it is. I'm looking for my correspondence with the institutional patrol at the General Hospital to get that specific answer. If you give me a moment, I'm looking through my correspondence with San Francisco General Hospital and our institutional patrol unit to get a better explanation of how that work division is worked out. I can try to get that in a minute.
Sure. Thanks so much. I mean, I think that we need to figure out who is responsible for the video footage, the surveillance footage at San Francisco General Hospital in order to really move forward in terms of his complaint and figure out what the party that would be responsible for these records, whether or not they're public, would be.
Member Patel.
Yeah, several things. I think I'm good with Mr. Garza for the moment, but I think I also want to be clear that this was not about medical records at all. You were maybe leaving an IDR with the medical record staff, but this particular records request is not about your medical records. Is that correct? Can you use the
microphone, please?
That would be a no, incorrect, because according to what I've been told by the San Francisco Police Department, they were informed that any activity on San Francisco General Hospital is considered a clinical activity and that I can't even video record. They couldn't even point out the fact that, video recording is not illegal. So under their advisement, the answer would be no,
Okay.
Thank you.
I'll come back to the video question. Mr. Nico, if you could take a second.
Yes.
The other mic. So let me just understand the framework for a second. I believe Mr. Harrigan was the counsel to the sheriff. He was replaced by Ms. Horn. Is that correct? And you're Ms. Horn's
legal
assistant?
counsel.
Okay,
Correct.
Just so I know. So the immediate disclosure request from Mr. Grant Garza was pretty extensive. You saw that, you referred to it.
Correct.
The only documents that you found in your diligent search in the Sheriff's Department were the incident and the unit log?
Correct.
And that unit log was very hard to review.
Right.
But in any event, those are the only documents that you found relative to that incident that the sheriff had.
Correct.
There may be other documents that exist in the world, but that's all that you guys had.
Correct.
And that was provided. You did a diligent search. You said that you're going to do it. You followed up. You had back and forth, et cetera, et cetera. You declined Mr. Garza's request to come in and meet with you and videotape and all that, but you provided him the records that he requested.
That's correct.
And that's all there is. You don't have anything else.
Correct.
If you had access to the video, would you disclose that, or do you not want to speculate at this point?
At this point, unless there was something confidential on it, which I don't know if it would or wouldn't, but the investigation, there was no pending investigation, so I don't think there would have been an issue of if it was available to have turned it over.
Okay. So let me further understand. The function that the Sheriff's Department provides at SF General is the security function only on the premises. You're not the police at SF General any more than you're the police anywhere else in town. The police department does police work and arrests people and does that sort of thing. You merely provide institutional security at SF General. Is that pretty correct?
Well, it's correct.
Right.
However,
or is it more
the
complicated?
Sheriff's Department are peace officers, so they do have arrest power at San Francisco General Hospital and the surrounding community. So the police
yes
can
and
also...
no.
Correct.
Okay.
They can do both.
And in this case, the incident involving Mr. Grant Garza, he was detained, arrested, whatevered, by the sheriffs or the police,
That's
or a combination?
Correct. From my understanding, it was a sheriff's issue. I can pull that report. I think I included it in your packet of who the originating agency was.
Okay, so it came as a police report, but the sheriffs can actually arrest people, and then the police file a police report, and it's sort of a joint thing? Is that how that works in that
It depends
case?
how it's originated. If
Okay.
Mr. Garza was detained on the street by the police, it would be a police report. If he was detained on the street or on the premises of San Francisco General Hospital, it would be a sheriff's incident report. Just depending who the originating agency is.
Okay, and what you provided, I thought, said it does. It says San Francisco Police Department incident report.
So he was arrested by the police, and I believe at San Francisco General Hospital, there was a police report which indicated there was certain property from him that was taken.
Right.
He was looking for specific property to obtain back. I think it was some cameras,
Yeah.
which were listed in the police report. Therefore, those cameras or anything taken from him should have been requested from the police department,
Okay.
which I advised him also.
And the reason that your department had this police department incident report is because the incident occurred at SF General?
I'd have to look at the police report to find out what the facts of that case were, but
generally you don't have police reports, the police department does, right?
Correct.
Okay. All right, and by the way, in our packets in the future, and maybe this is to Victor and to Nick, I hate to say this, but Mr. Grant Garza's social is listed. That's not great. Can we really try to redact those things on our end before they go out? Thanks. So I think I'm pretty good with the Sheriff's Department. You provided all that you had, and that's all there is. So maybe I can turn to Ms. Soraya for a moment. We didn't have in our packet anything that I saw from the Department of Public Health in response to Mr. Grant Garza's request. Mm-hmm. Did you provide anything to the task force?
No.
No. I'm sorry, were you requested to do so? Did you get notice of the hearing, all of that?
And we just didn't have any documents responsive, at least for this hearing.
I'm sorry, didn't you say that you responded to Mr. Grant Garza's initial request?
Yes, that's correct, yeah.
And you didn't provide us a copy of that response so that we could evaluate whether you had a complete and timely response?
That's also correct.
Is that your... That's a problem. I mean, how do we get that information? Because we need to evaluate.
This is not in my defense, I was brand new to the role, and I wasn't sure how the Sunshine Task Force process worked. I mean, Eileen Shields had just left, and I had taken over for her 2 weeks prior. So, this was literally my first Sunshine request that came in.
Okay, but
it's like I said, it's not an excuse.
Do we have that information now? Do you have copies that you can provide us?
I have a copy.
Okay, maybe if you could give that copy to Victor, we can have it in the file and we could circulate it because we need to evaluate. It doesn't appear to us that there was any response from DPH, and that's kind of a problem for me. Can you summarize for us what your response was to Mr. Grant Garza?
As I believe January 28th was the date that we responded to him saying that there was no video footage that we were aware of that would be responsive to his request.
Was there a response within or by the close of business of the following business day?
There was, invoking an extension of time, yes.
Did you provide that to
Yes.
us as well?
Mm-hmm.
Okay. And as to any other documentation, any of the other paperwork that he was asking for? Did you search for and did you find anything?
We searched and nothing was found. There were no responsive documents. And
Okay.
that was also in the same email.
And that was communicated?
Yes.
Okay. Are you two still sorting out who's responsible for the video?
Yes.
I have an email from the institutional patrol captain to him from an Eric Kondo, Kondo, the chief engineer for the San Francisco General Hospital and Trauma Center, which indicates that in attempts to retrieve the video footage in question, it was verified that this video was not available. The loss of video was the result of the final step of reconfiguration that was needed to stabilize our archiving system by the installer, Siemens Building Technology, and the manufacturer, Lenel. The loss was not planned for, but due to some reconfiguration formats that needed to be applied, the loss of video, approximately 3 weeks, was unavoidable to move forward with the process despite exhausting efforts to try and preserve them. This is information that's consistent with my response to Mr. Garza indicating that the video was not available anymore.
Due to technical reasons?
Correct.
Okay. So I'm not sure that I'm putting this on either of you, but it just seems almost unbelievable to me. After that woman was lost and disappeared and was found deceased at the hospital, this is like 2 months later, and the video for 3 weeks of routine taping at the hospital is not available due to a reconfiguration of some equipment? That's scary, sort of.
I certainly can't answer for the hospital or the sheriff's department regarding what video was referred to or what video was affected or not. I think that's a bigger question I'm able to answer right now. We were looking for a specific video, specific location for a specific date.
Okay, so it may or may not be a broader problem.
Right, I can't answer.
But in any event, and just finally for me, can you, since you're, can you help me with the question of whether or not videotaping, as Mr. Grant Garza appears to be doing now, in this room in a public building, why that would not be legal at SF General in the medical records office? I'm just wondering.
Well, because the medical records office, I haven't done any research on this. My initial reaction, though, is the medical records office could have confidential information available or confidential conversations going on. That's why people need to be advised of it and agree to it.
But in the absence of specific documents being in sight or a conversation occurring, is the general practice of videotaping at a public facility permitted or not permitted?
I haven't researched that for today. I would say there are exceptions. I think public places is certainly an exception. Public buildings, there are exceptions. Actual specific people in offices, I think there are limits, and depending on where you're talking about and where in an office you're talking about.
Okay.
Excuse me.
Thank you for your answers.
Members and Member Wolf and then Member Highland.
So, Mr. Nico, thanks for getting that information around the facilities. I'm still kind of at a loss. Like, that information came from you, but the way you said it, I'm still confused as to whether it's the responsibility of the sheriff's department or the facilities at SF General who maintain that footage, and whether there was a failure on the part of the sheriff's department and the technicians that were hired on behalf of them, or SF General and the technicians that were hired on behalf of the Department of Public Health that are responsible for this loss of the footage. It still remains unclear whose job it is to be the administrator of that information.
I understand that confusion, and based upon the information that I got, it's pretty much you now know what information I received regarding the video. I was advised the video was not available. I did not inquire into whose responsibility it was. I can't answer that for you now. I would certainly, if that's a question you have, try to answer that more specifically for you. But in regards to what video was available for this date, I was advised it was not.
Right, I understand that. But in what you just read, you spoke of a particular job role that gave that information, and it's unclear to me whether that job that you referenced is within the sheriff's department or within the Department of Public Health.
Who was the guy that you named? Corbu?
Let me find it again.
Kondo?
Mr. Kondo, Kondo. Facilities manager, I think is what he said he was. Or
Excuse me, Mr. Garza? This video.
Let me ask a question to Ms. Soria while Mr. Nico's
Yeah,
looking up
find
that
out,
information. The video that we watched transpire in Mr. Garza's presentation, never mind. That's actually, I don't need to ask that. It's outside of our purview, actually, so I apologize for starting a question and stopping. Mr. Garza, I have a question for you. The video that you showed, was that was after the arrest, or that was when you were trying to get records pertaining to that arrest? What were we watching there?
Unfortunately, haven't been in front of you guys many times in many incarnations. I've only been detained and arrested falsely and 5150'd falsely in seeking my medical care and medical records. That's why I've continually told you that I'll continue to come back until I'm dead, apparently, and recreate the wheel numerous times because you people are unfathomable. In response to your question, I've been illegally 5150-918. Amazingly enough, the Sheriff's Department didn't have copies of those videos nor copies of the policies, just like the Sheriff's Department and
Respectfully, Mr. Garza, could you answer
What was the date of the video that you showed us?
11/27/13.
11/27/13. Great, thank you. So you were seeking the video footage that corresponds to what you just showed us, is what you're saying?
Correct, because if you go in the hallways, you'll see that there's cameras there that have video footage, and everything. They're taking video footage. According to the city attorney's false interpretation of HIPAA, that is a public area, and I am entitled to video record, especially walking inside to the medical office records. There's a place to sit for the people to sit and everything else. There's a desk to be helped. That's a public area. This representation that I'm trying to videotape something else other than the receipt of what I'm seeking is a false red herring that they're using to divert from the subject. That they don't have any policies. As a matter of fact, I was told by the CIT officer, Kelly Kruger, at the San Francisco Police Department, and Mr. Tad Yamaguchi, that as soon as I step foot on San Francisco General, I give up all my rights to medical and legal care because the sheriff has sole jurisdiction.
Okay,
there.
Mr. Garza, were you given a reason for the arrest or the detention?
As a matter of fact, I've continued to try to follow up with Mr. Yamaguchi to file a complaint against the false arrest record in which they described me as being a certain way, which I wasn't, which my video proves, and that was the reason I was trying to get their videos to show that everything that was represented in the police report, the incident report that was given about that incident, was false, and that all the characters were playing their part in basically poisoning the well against me and saying incorrect things.
Excuse me. I'd like to urge everyone to stay on point. We have some very specific issues we're addressing. We have a long agenda tonight, and there are a lot of interesting aspects to this, but we have some specific issues that we're dealing with.
Thank you.
So I would request this of everyone.
Mr. Nico, do you have an answer to the inquiry?
I did find the person we were dealing with was Eric Kondo, Kondo. chief engineer at San Francisco General Hospital.
So he would be within the Department of Public Health and not the Sheriff's Department then?
Correct. He did liaison with our captain out there to try to obtain this video, and could not be obtained by either side.
Great. Thanks.
Member Hyland, then Member Rummold.
Ms. Soraya, a question for you. I appreciate that you were kind of thrown into this role last minute, but unfortunately it doesn't exempt your department from sending someone knowledgeable about basic things like who keeps video records. So I'm tempted to find a violation of 22A for that reason. And sorry to throw you into the fire this way, but it's a good way to kind of understand, the responsibilities of keeping up with Sunshine for your department, because it seems like what exactly is your task?
Public Information Officer.
So that's something that I think going forward you'll probably have to be a bit more responsive and a bit more circumspect in your investigations to get these answers to the members of the public. Thank you.
Member Rummold.
Mr. Nico, or I suppose this is for either of you. Mr. Garza also requested policies related to retention of the videotape in the hospital. Has that been produced by DPH or the Sheriff's Department? I know it's still something of an open question. Who's responsible for that?
I did respond to that, indicating that the Sheriff's Department does not have written video retention policies or procedures. That's what I know. That's what I was told. That's why I responded to him. Where they are in the hospital, at all, if at all, I do not know. Are they needed? Again, I do not know, but after this, I will find out what the specifics with regard to video retention and just who's in charge of that video equipment.
I have some questions for Ms. Soraya. I have the document. I guess you gave this to Mr. Young, right?
Yes, just now.
This all would have been very helpful for us to see. Our DCA prepares a memo for us recapping some of the highlights of the case, and none of this was available. I read through the materials in preparation for today's meeting and was under the impression that DPH had not responded to Mr. Garza in any way whatsoever. So now we see that you did respond to the immediate disclosure request asking for some additional time. And Mr. Garza asked for quite a list of things. But when you finally then got back to him, you just responded to the video footage and none of the other information. So it isn't clear to me whether or not you had other information that you didn't address any of the other items that he asked for in his IDR. So how did you respond to him in emails other than the ones we have here, or?
Those are the only ones we responded with.
So the only thing you addressed was the video footage. You had nothing to say about the others. You didn't say, we don't have this type of information. There are no emails or memos or anything else related to this. The only thing would have been the video footage, and it doesn't exist.
Mm-hmm.
Okay. So this wasn't terribly helpful to him at the time. So just in the future, make sure you fully respond to everyone involved. Member Wolf, you had...
Yeah, just a real quick question, Mr. Nico. Did you say that there are no video retention policies with the Sheriff's Department or in regards to SF General Hospital?
In regards to SF General Hospital facility.
Great, thanks.
And for the Sheriff's Department at General Hospital might have their own retention policies for their hospital, but the Sheriff's Department itself does not have any video retention policies for the facility at General Hospital.
Great, thank you.
In regards to the policies, we did respond to Mr. Garza informing him that we don't have any video retention policies at San Francisco General Hospital.
All right, Member Pilpel.
Right on time. So on that question about the retention of videos at SF General, we just did a look over here at the city's index of records, which compiles the department's record retention policies and schedules, and found that there's hospital data, but it's kind of vague. It's administrative records. There's no specific category in DPH's record retention policy and schedule for surveillance video. There should be, because it's a record. You're creating a record, and you've got to classify it under Chapter 8 of the Admin Code and determine what type of record it is and what the retention period is, et cetera. Francis Culp is your listed departmental contact. If you don't have a policy for it, it's a record, and you need to have a policy and schedule for its retention. You don't have to necessarily keep it forever, but you do need to indicate how long it's kept and what type of record it is. It's all we do around here is create records, and we've got to figure out how long to keep them. There's a whole process for that. So if you can follow up with Francis on that, that would be great. And ultimately, I think we heard a lot now about the video, but between your two departments, I think you need to have a clear answer about who's responsible for the equipment and who does what out there. Thanks.
Member Rummold.
Yeah, I would just echo that comment with regard to the sheriff's office at SF General. It seems like I'm looking in some of the documents that were produced, there's a sheriff's substation room within SF General. And I'd assume there's a video camera in that substation room. And if you all have a broader, video camera retention policy, it should apply to the camera in that room as well. So I think it's worth figuring out what's going on with the video camera retention policy at SF General.
Chair Washburn?
Yes. Member Hepner.
In the index of records for the Sheriff's Department does indicate a category of records, audio-video recordings, on-site storage period 1 year, off-site storage period 6 years. So there is a retention policy. The index of records is something that should be referred to, and could have been told to Mr. Garza to refer to that on this topic.
And it just, I haven't referred to that, but we do have, I know that we are in control of video equipment in the jail facilities, and I think that's what that normally refers to, but I'll make sure to see if that also would be extended to any equipment we might have at General Hospital if we do.
Thank you. Members? Any more questions? All right. At this time, first the Sheriff's Department, and then Ms. Raya from the Department of Public Health. You have up to 3 minutes to offer any additional information, thoughts, rebuttal.
On behalf of the Sheriff's Department, I would just rely on my introductory words, and that is request. And that the question with regard to the video that the Sheriff's Department had was that whoever controlled at that point could not obtain the records he was talking about because they were not available. That was confirmed by the Sheriff's Department and from San Francisco General, and was told to Mr. Garza. So we will certainly take under advisement the wisdom of having policies at General Hospital, and we'll get to the bottom of who has control of the video at General Hospital. But the fact is, the information known to the Sheriff's Department was given to Mr. Garza in a timely fashion. Thank you.
Thank you. Ms. Raya?
On behalf of the Department of Public Health, I want to echo Mr. Nico's words. We will look into our retention policies as well for video. We did lack on our part in responding to certain parts of Mr. Garza's request. That was an oversight on our part. We will make sure that doesn't happen in the future. And I just want to say that work and the efforts in trying to locate the video footage for Mr. Garza. It was a collaboration on our part and the Sheriff's Department. The Sheriff's Department is a contractor for us, and we did our best to locate the video footage, but we'll be more clear in the future about who manages video.
Thank you. At this time, Mr. Garza, you have up to 3 minutes.
What is really harmful is the fact that, every time I'm taken in, falsely arrested, falsely 5150, it's me seeking my medical care through the Department of Public Health, which has repeatedly violated the law. In 2001, when I was denied emergency services, I brought them to the Sunshine Task Force and received a letter from Mr. Harrigan, the predecessor, signed Nurse Ratchet. That's been documented, everything else. I also am the person who stands here with a signed confession from the Office of Inspector General for having been denied emergency services at San Francisco General, the only one of its kind that admits fault and guilt. My continual effort to be treated humanely, seeking medical care, and to hold these people accountable so that they don't move the goalpost. And let's not forget that, I went in seeking, medical records for a false 5150 that happened at the police station at Northern Station on 9/18. They, of course, have no video policies, or the videos that were taken at that point were missing also. This is incredible. This is as bad as the IRS scandal and losing emails. This is pathetic. I'm here to try to get what I have to prove what I'm saying is correct so that, I can uphold my integrity, seeking what is mine, in the public domain, only to be played by these people. Now, they keep bringing up this January IDR. Let's not forget that on 11/27/13, when I got home, I immediately sunshined them. And their prior counsel, Ms. Home, informed me that since it was under investigation, I was not entitled to these records, and I had to wait for 2 months until I had a notice to appear, which, of course, all the charges were dropped, so that I couldn't get in front of a judge to explain and show the videos of how I've been consistently denied my health care. And I've been continually played by the professionals with no policies, no humanity, twisting the law. And you people here forcing me to come in and recreate because you set no precedents. I'm sure that at the end of this meeting, when I come in next time for more medical records, the DPH will say that medical records are not a public record because there'll be no precedent here. 10 years of this. Are you guys just waiting for me to die? I continue to do the right thing. Does it matter? Apparently not. Thank you.
Thank you. The matter's back with the task force.
Through the chair.
Member Hepner.
I'd like to propose moving to find violations of 67.21 for failure to provide a public record, as well as a violation of section 67.29, which requires appropriate staff to review the index of records kept by the city administrator so that it's accurate. I don't believe that was done either.
Is there a second?
I'll second that.
Propose an amendment?
Member Highland, yes.
I'd like to add 6720A, failure to send a knowledgeable 21E representative. I'm afraid. 6721E, failure to provide a knowledgeable representative.
Does the maker and the second accept the
Yes.
addition? Member Wolf.
I don't know the code well enough to address how this should be amended to the motion, but I think that it's important that we recognize that whether or not Mr. Garza came into the SF General Medical Office with a legitimate, like whether that records request was a public record or not, he went in there with an immediate records request and came out in handcuffs. He was bringing a video camera, presumably because he wasn't sure whether his side would be adequately recorded, which I'm assuming is why he's filming us right now. And he was concerned that that video might disappear, which was why he filed the public records request for it. And then that video mysteriously disappeared, which is probably around the fear of why he had the camera in the first place. So there's this rather Kafkaesque experience that he's gone through that I don't think our city employees have necessarily been as sympathetic to as they could be. Now, I don't know which of these aspects of the Sunshine Ordinance are addressed here, but I think it's a real issue when people come to any public building, public office, with the exception of maybe a trial courtroom where there is a standing bar on cameras, and leave in handcuffs for trying to file a public records request. That's really, really chilling, and I think we need to address that in part of our motion here.
Well,
Member Pelpel?
to Member Wolf, much as I agree with you and I'd like to, I'm not sure that that's within our purview. I think all that we can address here is whether the records request was responded to. And I appreciate your version of events, and it's true, but, this, like all of these things, there's a story here. And we, some of us have seen Mr. Garza before, and on the motion, if I could, to the maker, is this to both departments or only one?
67.29 is certainly to both departments, and there's some ambiguity over who has control over the videotapes, which were not produced. And in light of that ambiguity, I suppose that it should apply to neither or both, but I think that for our purposes, it should probably apply to both. I think that, if I may piggyback on what Member Wolf was saying, I think one way to deal with that is to find a violation of 67.34, a willful failure of the Sunshine Ordinance. I do find it suspect that this video mysteriously disappeared following an arrest at DPH.
Well, okay, I guess...
Member Pelpel.
I guess I would like us to be clear on which department or which actor we're finding a violation. So why don't, if you can maybe think about that for a second, and I guess where I am on the matter, I generally believe that the Sheriff's Department complied on a timely basis and provided the records that they had. And although I'm not entirely crazy about the DPH's response, particularly since I only saw it, in the last few minutes, I think generally that also was timely and provided the records that they had. Should they have kept the video? Should they not have had a technical problem? Yeah, but they didn't have it. So I don't know that there were any records that were withheld. I didn't hear that, and I didn't hear that there were any records that were not timely provided. So I'm having trouble finding a violation here, quite frankly. Maybe I'll just vote no.
Vice Chair Hyland?
Through the chair, I think on reflection of that, I'd like to withdraw the 21E, pose that as a separate motion against DPH solely, and vote on the first two that you proposed. So I'll propose that as a separate motion. 21E, failure to provide.
You can just divide the question, and then that just happens.
Okay.
All right, so right now we have one motion that finds a violation of 67.21. Is 21...
21A.
21A. And 67.29. And are these for both departments?
I'd be interested in hearing from members as to whether 6721A should apply to either the DPH or the Sheriff's Department, one or the other, or both, to the extent that it should apply to either. And I think the question is who had control over the cameras.
Member Rommel. Member Oka.
I'm really having trouble with this whole process because Mr. Garza is asking for records, whether medical or not. They're his records. And so for him to be denied access to his records in and of itself, we've been through this time and again. I think we know that he has a right to get his records, medical or otherwise. So, what are we talking about? There is a violation, and I think we should do both parties in this. So 67.21 and 67.21A applies, in my view, to both DPH and the Sheriff's Department.
Member Wolf.
So this might be a little bit outside the box, but in terms of what is within the purview of the Sunshine Ordinance, it seems like 67.1A, government's duty is to serve the public, reaching its decisions in full view of the public, was violated by DPH in the video that we witnessed, as long with D and G, also 61.A, D, and G. And I can read those as well. The right of the people D is the right of the people to know what their government and those acting on behalf of their government is doing is fundamental to democracy. And with very few exceptions, that right supersedes any other policy, interest government officials may use to prevent public access to information. Only in rare and unusual circumstances does the public benefit from allowing the business of government to be conducted in secret. And those circumstances should be carefully and narrowly defined to prevent public officials from abusing their authority. And G, private entities, individuals, and employees and officials of the city and county of San Francisco have rights to privacy that must be respected. However, when a person or entity is before a policy body or passive, it's not technically a passive meeting body, so I'll scratch G from my suggestion.
Member David, and then Member Rummold.
Yeah, I just want to be very careful about how we define public records. A medical record, as we've discussed before, is not, I cannot go in to San Francisco General and request someone else's medical record. Therefore, that is not a public record. I should be able to get my own record, but that's different than a public record. And I just want to be very careful that this is the issue that has come up before with this particular in these types of cases in the past, is individuals' ability to get their own records. And I remember in past cases, there was another path for Mr. Garza to go down to go get his own record that he chose not to participate in. Okay, so I just want to be clear that there is a difference between, in my mind, a public record that any one of us should be able to go get and a medical record that, I should not be able to get Mr. Wolf's medical records, but Mr. Wolf should be able to get them. That's all.
And I just wanted to say, I've been around the task force for quite a long time now, and we've heard this matter numerous times, and Member David's correct that no one has the right to other people's medical records, and it's been the policy of the city and county, the San Francisco General, to, if you want your own medical records, to sign a form to receive it, and then it's given to you. And that's something that Mr. Garza has taken issue with. So that's kind of the issue that he's been grappling with that's brought this to a head. But I just want to urge everyone to, in considering how to adjudicate this, how in a motion to be voted on, is look at what was asked in this case, and what was asked for in this case was a video of that incident and records relating to that incident. It was nothing about obtaining the medical records. So I'm right now tending to think that the Sheriff's Department they were diligent about their timeliness of their response, the thoroughness of their responses, pinpointing everything that was asked for. Yes, that's not clear about the video, how that whole situation worked. That seems to be a mystery. But nonetheless, they were timely and thorough in their responses. DPH, on the other hand, I thought their response was inadequate. they did respond, not that we knew about until just a few minutes ago. But DPH did not, in fact, go through each of the items requested and say, no, it was just, we don't, we need some more time, and then, oh, we don't have the video. It was not an adequate, in my opinion, an adequate response. So that's how I'm looking at it. But I'm interested to hear from more people. Vice Chair Hyland.
Perhaps maybe the maker of the motion would consider splitting the motion against the two different respondents. We can vote on both. That might be expeditious at this point.
You can request that, and that happens too.
So requested.
So according to Robert's rules, we can divide the question?
Yes.
Okay, all right. So how did the Member Rummold and then Member Pilpel?
I keep bringing up the policies issue, but Mr. Garza definitely requested policies for video cameras and retention of data, and the Sheriff's Department indicated here that they do have a policy, but it appears that policy was not provided to them. So I think violation on the part of the Sheriff's Department for failing to provide information for them. But otherwise, and to get to Mr. Member Wolf's point, I don't think it is wise for us to weigh in on the wisdom of the arrest, whether or not it was, I hear what you're saying, but I just think it's well outside of our role in deciding public records cases to address something like that.
Member Pilpel.
So a couple of things. I'm still open to a 21E violation with respect to DPH. We'll reach that in a bit. I'm having a problem with two things on the 67.1 citation. It's great verbiage. The problem is that it doesn't impose a specific burden on any department, so it's difficult to find a 67.1 violation for anybody. It's just flowy preamble language about how open government is a great thing and we all believe in it. It's these other provisions that impose specific burdens on departments where they either did it or didn't. So that's why I'm having a problem with 67.1. And then again, as to the records requested, and I appreciate Chair Washburn's reminding us, the request was for all videos and all documents generated concerning the incident on 11/27/13. The documents were the incident report and the log. Those were provided. Apparently DPH had nothing in terms of documents. The video was requested. The video wasn't available. Video should have been available, but it wasn't available. Had it been available, that would be a different thing. It wasn't. So what was requested, what was available, was provided. I believe it was done so on a timely basis. The policy about the video retention of the sheriff, it's not clear to me that the sheriff is actually the custodian of the video at SF General. It sounds from what was explained to us that it's actually SF General facilities that's responsible for the video retention, and that it's DPH's video policy, and they said one did not exist, and it appears that one does not exist. Should it exist? Yes, but doesn't, and he was told it doesn't. So I guess I'm still not finding a substantive violation, possibly a 21E violation from DPH, but that's where I'm at.
Member Rummold and then Member Hefner.
Yeah, I just want to respond really briefly. So his request says to the sheriff, also send me a copy of the policies regarding the video cameras and retention of data per sheriff's office. That to me doesn't seem limited in any way to SF General. It's a request for the sheriff's video retention policies, which they acknowledge they have and which, in my view, should have been provided.
Okay. So Mr. Garza's request was more broad than how the Sheriff's Department responded.
Well, in my view, I think that last line at least was with regard to the policies, sure.
Okay. Member Hefner.
I'd like to modify my motion along the following bases, and I'll provide a brief rationale. I think that I want to maintain a a 67.21A violation against DPH for failure to produce the video. I don't see that there's an exception to producing documents if there's a technical failure and they don't exist anymore. I think that to use that as a basis for finding that there was not a violation encourages further technological failures. And I think that the video lands with the DPH in my mind because we have this gentleman, Eric Kondo, who is employed by DPH or the General Hospital, asserting some sort of, control over that videotape. I would find a violation of 67.21A against the Sheriff's Department for failure to provide the policies that were requested. I would find a violation against 67.29 against both the DPH and the Sheriff's Office for failure to check with the Index of Records and make sure that their video retention policies are up to date. So that's my motion.
And just
that's the amended. Yeah. The seconder accepts.
And through the chair, just to be clear, my 21E was only against DPH, not the Sheriff's Department.
So that's a separate motion? Okay. Do we have a second on that separate motion?
Second.
Okay, I have a question about the main motion. Well, the other motion, I won't say the main motion. Member Hepner's motion. So we have three different violations and two different parties. Do we want to separate out these things by the departments?
If need be, is there a way to test the temperature to see if we can just take a vote on the package?
I think unless there's an objection or a request to divide, then we just take the motion in toto, and I think that works. And then I would suggest that we take the 21E matter separately.
Member Oka?
According to my reading of the rules of order, we cannot do two motions at once. One has to be voted on and either up or down, and then we take the second motion.
Well, I think that's what we were planning to do. Yes.
This is a single motion to find violations of 67.21A against both the DPH and the Sheriff's Office, and a violation of 67.29 against both entities as well. That's one single motion.
That's
four violations, one motion.
Right.
All right. I'm sorry. I didn't realize that it was both violations against both departments. Okay.
That's one motion.
All right. So everybody clear on the motions? There are two motions. We will not be voting on them at the same time. We'll vote on them one by one, but let's have public comment on the first motion.
I just would like to clarify, just to be sure that we're clear what the two motions are.
Okay.
We have one motion concerning both parties. The motion is concerning 67.27A and 67.29, and that was moved.
No.
67.21A.
That's 67.27A or
21A.
67.21A and 67.29. That was moved by Member Hepner, seconded by Member Oka. And the second motion is to find the Sheriff's Department in violation of 67.21E.
No, the Department of Public Health.
Sorry? To find the Department of Public Health in violation of 67.21E. That motion was moved by Member Highland.
Seconded by Member David.
Seconded by Member David.
But I think on the first motion, can you read that back?
That was to find violation of both the Department of Public Health and the Sheriff's Department in violation of 67.21A and 67.29.
And did we want to be specific as to what? Because I heard very clearly from Member Hepner that it was DPH on 21A as to the video, the Sheriff's Department 21A as to the video policies, and 29 for both departments about not updating their index of records.
You're correct, and I think that would also make it into the order of determination.
Okay, but I just want to be sure that all.
That would be the motion concerning 64.21A concerning DPH for the provision of the video, and the Sheriff's Department for not providing the video policy, and 67.29 for both departments regarding the updating of the index of records.
All right, and now I guess, mindful of the time, I'd like to hear public comment on both motions would be fine.
Patrick Minute-Shaw. I was disturbed that 67.1D was tossed into the mix. The right of the people to know what their government is doing is not what Mr. Garza is doing. Our government is not, how do I phrase this? Basing our democracy on his medical records just doesn't add up. CIPRA section 6252D defines public records as including any writing containing information relating to the conduct of the people's business. This is not the people's business. This is his medical records. He then goes out, gets himself 5150'd, gets himself arrested, and then to appear before you, turns it into a battle over public records for the arrest and the 5150. But this is ultimately about his medical records. He sat here and testified in his response, his 3-minute response and his 5-minute testimony, that this is all about his medical records. And you guys just keep letting that go inside in one ear and out the other. To him, in his mind, this is about his medical records. And the Sunshine Ordinance is about the people's business and the conduct of public records. You need to find a way to keep him from coming back and wasting your time.
Good afternoon, Task Force members. Richard Nee. Respectfully, I would suggest that you consider adding to the list of violations failure to maintain records, specifically the video, in a professional and businesslike manner per section 67.29-7.
Thank you.
Yeah.
Is there additional public comment? Members, any interest in adding 67.29-7?
I understand the basis for it. I also think that it's adequately covered by 67.29, their obligation to make sure that the index of records is up to date and to review that.
I'm not sure.
Understanding there's a slight difference there. Would you? I mean, if there's, I'd like to move things along, and
No,
if there's a desire to add that, and reach consensus.
I want to get this right, and so 67.29 deals with the index of records. 67.29-7 had the records been kept in a professional manner, this transition they went through where things got lost, the records would have been available. And possibly we wouldn't be here. So that seems to be more basic. Or, I mean, basic, it is different. Member Oka?
Let's add it. Yep. Okay.
So, Member Hepner, do you want to revise your motion?
To add a violation of 67.29-7 against DPH for failure to maintain the videotape records?
Yeah.
Yes.
Or that could be a separate motion.
I'm comfortable adding it on.
Member Oka?
Yes.
Okay, do we want to members, discussion? Do we need additional public comment? Okay, all right. At this time, Mr. Young, would you call the roll on?
There are two motions. The first motion, moved by Hebner, seconded by Oka, is regarding finding violation of 67.21A to DPH regarding the provision of the video, and the Sheriff's Department for not providing the video policy, and 67.29 for both departments regarding updating the index of records, and the Department of Public Health for Sunshine Ordinance 67.29-7 for not maintaining proper records. On that motion, Member Rummel.
Aye.
Rummel, aye. Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
No.
Pilpil, no. Member Hebner.
Aye.
Hebner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The second motion is to find the Department of Public Health in violation of Section 67.21E, moved by Hyland, seconded by David. On that motion, Member Rummel.
Aye.
Rummel, aye. Member Winston. Winston absent. Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
Aye.
Pilpil, aye. Member Hebner.
Aye.
Hebner, aye. Member David.
No.
David, no. Member Fisher.
No.
Fisher, no. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. Is there any referral of these items?
I think this should go to EOT. I don't see any basis for sending it to compliance and amendments.
Do you have any instructions to the as to what shall occur at EOTC?
I think a discussion about maintaining the index of records in a way that's informative. Also, policies regarding creation, maintenance of video records. I think it would, the parties would benefit from a discussion of, who's responsible for that, so that these records don't, or these surveillance records don't fall through the cracks.
Through the chair.
Vice Chair Hyland.
I'd also like to see just their general sunshine request policies, if they have one.
Both departments?
DPH.
Yeah. It probably would make sense to have separate agenda items for each department rather than bringing them in together, because they're somewhat different issues.
I will divide the file and provide a separate order of determination for each party.
All right, thank you. Member Pilpel.
It would also be nice if when DPH comes back or in their written response, if they would indicate that if there are any further issues regarding SF General and its facilities to address the 21E violation, that they would have their facilities person here, so we didn't have to spend all that time trying to figure out who's responsible for stuff. I think that was...
All right, thank you.
Name Mr. Konda, maybe.
Yeah, Mr. Kona.
Konda.
Mr. Koda?
Kondo.
Kondo.
Honda.
Maybe we'll get a conversion.
Okay.
Too early for that.
Right.
Next on the agenda is, prior to moving to public comment, I just wanted to inquire if Ms. Deanda has arrived. I did try to call Ms. Deanda. I did not receive an answer to her phone.
Was she the woman that was here before?
No.
Okay.
No, she was the ADA person.
May we move to public comment? I'll try to call one more time, and then we can make a determination.
Right. I would like to take public comment now, and then I would like to have a recess It's been our practice to call for a recess around 6 o'clock.
Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Task Force jurisdiction but not on today's agenda.
Mr. Garza?
Yes, hi, I'm here for public comment. Once again, you guys have screwed the poochie. No precedent. Once again, I guess the next time I need my medical records, which are public records, I'll be here again because you guys have screwed the poochie. No precedent. Amazing. Before, you've ruled that medical records are public records, but you screwed the poochie here again, so I guess I'll have to reinvent the wheel again. No precedent. This has happened many, many, many times. Also, I've recently submitted another complaint for denial of my medical records on 430, 723, and 729 at the San Francisco General Hospital that I submitted to the administrator, who incorporated all 3 incidents into one item, which is incorrect and has not been responded to. I've said in the past that you people never respond to, the way things are conducted here appropriately. The thing that Ms. Washburn had said as far as me having to sign a HIPAA release form to get my medical records, Ms. Glaycorn, in front of this august body on 5/19, stated to you guys that I did not have to sign for my medical records, and that was a canard. But it was a lovely way for you guys to poison the whale against me when it comes to, he was offered another way to get his medical records, but he's just being obstinate. He's just being difficult. No, he's actually following the law. But he doesn't have people, sycophants, bending over backwards to allow incorrect agencies, incorrect law interpretation to persist. Again, you haven't made any precedent, any policies here regarding one's own medical records and whether they're public records or not. Again, the false canard about having to sign a HIPAA release form to get my own medical records. I actually have a HIPAA release form that was sent to me where it says you don't have to sign. Maybe you should ask the Department of Public Health about how you guys are being played. Oh, no. Let me rephrase that. How you guys are willing patsies to be played and to further harm people who are here trying to get what they need to defend themselves against egregious conduct. Oh, it's wonderful, it's marvelous, but guess what, guys? This is another video on YouTube to continue to show how ineffective you guys are. Oh, and if you do by any chance, like last time you sent Miss Eileen Shields for not being, knowledgeable person here, up to ethics, that wasn't acted upon. Oh, I've got that paperwork too, to show the complete and total farce. And if I have to be here to berate and belittle you guys consistently until the day I die because you have no soul, no shame, I will. Because I'm doing what's right. And the misrepresentations and to say that I have to sign a HIPAA release form is false. Thank you.
Patrick Manetsaw. Next time Mr. Garza files a complaint, send him to Complaint Committee, Siberia. Don't let him come waste your time here. I'm so sick of hearing about his medical records and his 5150s and his arrests over his medical records, which are not public records. Speaking on a matter that is not on tonight's agenda, at your special meeting a week ago, I came and presented copies of my appeal to the Ethics Commission that I'll deliver on September 22nd, appealing the dismissal of the second complaint against Task Force member Pilpul. In the appeal, I noted that Mr. St. Croix made no mention of Section Roman numeral 3B1 of the SIA that restricts Mr. Pilpul's behavior since he is a member of a specific position. So I'm going to remind you that later this evening, You need to keep in mind that when Mr. Pilpels utilized ex parte communications with the Ethics Commission, he pretty much put himself in the position that for tonight's discussion on what to do with the Mayamchi matter, he needs to ethically recuse himself from the discussion and the vote. And if he does not, one of you should make a motion to have him recuse himself from this discussion. Because after all, the ex parte communication involved you. He didn't feel like it was necessary to consult with his fellow task force members before trotting over to ethics and trying to subvert your order of determination in the Mayamchi matter. So he should not be part of tonight's discussion because he's already put himself under the noose.
Thank you. Is there additional public comment at this time?
Hi, I'm just here to say what I said last time, which is if you could move the Arts Commission compliance case up to the next meeting. Nobody asked me what if it was okay to put it over for 4 months. It's actually disrupting my plans a lot, and because I brought the case, I feel a responsibility to be here and argue it to the end. What I said last time is the Arts Commission has put forth no good faith effort to change, and I don't believe a month and a half or 4 months out will make a difference. For example, the community arts meeting minutes posted late, the last one, and I sort of have to prod them along by email. The meeting today of a policy body, it's called the Advisory Board of Craftsmen Examiners, where they're setting criteria for street artist permits. The agenda, I looked at it for like 2 hours last night. I could not make sense out of that agenda. I read the items. I couldn't understand what it was. And also the audio doesn't post on the internet, so that's a confusing issue. The most disturbing to me is what the last time Kate Patterson was here, she was pregnant, and I raised the issue while she's going on maternity leave. What plans do they have in place for the custodian of record, sunshine request, public record person? And we didn't get much of an answer. Well, it's kind of fallen through the cracks. Just as a test, I sent an email to her, an IDR. There was no response. It didn't kick back to me saying, I'm out for 6 months. I'm going to refer it to so-and-so. Nobody picked up her email. She's still listed as the public information officer on their website. So any individual for the next 6 months who's going to make an IDR is going to get a violation, no records, because they haven't set in place any provision for that. So I'm hoping that you can push my case up to the next compliance meeting.
Is there any additional public comment? Okay, seeing none, I'd like to...
May we take action on the Deonda case prior to our recess?
Sure. Mr. Young, have you tried to reach her?
I did try to reach her via the telephone. I did not receive an answer. She was informed via email of today's hearing, and I did have various communications with her regarding today's meeting, and I have not heard.
Member Wolf?
I'm just curious why we're taking action when we're about to go on a break, and she could conceivably come during that break, although probably won't anyhow.
She's 2 hours late already.
And plus we have, it really is not your concern, but we have a person here who is here to do ADA services for Ms. Deonda, and I did not want to hold her up if we did not have to.
So, move to conclude or move to
All right.
dismiss? What's the
No,
appropriate?
just a minute. Member Pilpel.
I was actually going to suggest either we dismiss the matter. We could actually hear the matter on the merits now. We could hear the matter on the merits without the complainant. We've done that on occasion. And depending on where we go with it, if the complainant wants to reopen the matter, certainly could. If we dismiss it now, I think the complainant would have to start over. And I, too, am concerned about the cost to the city for the ADA accommodation.
Vice Chair Hyland.
I move to dismiss.
Second.
Need to take public comment.
Okay, this time public comment on the motion to dismiss this case. Be interested to hear what the public has to say.
Good evening, Thomas Piccarello. The motion is to dismiss the case because the complainant didn't show up. Is that the motion?
Yes, it is.
Okay, so I'm in opposition to the motion. I would prefer to see that you take the matter off calendar and at the call of the chair. I mean, that's been your consistent policy in the last 2 years, so I don't understand why now you're going to dismiss. If this is the first non-appearance by the complainant, I wouldn't dismiss. I would leave it on calendar, and then it would be at the call of the chair. So just for sake of consistency, I would oppose the motion to dismiss. Thank you.
I have a question of Mr. Young. This case seems familiar to me.
This was scheduled at one time before, and it was continued due to
continue because of...
we could not provide the ADA accommodations at that prior meeting. There was not enough notice.
2 months ago for the July meeting.
So...
and this is the rescheduling, and we made provisions for ADA accommodations, and I have not heard that she would not appear.
All right. Mr. Minetshaw.
Thank you, Chair Washburn. It's going to be a rare day that I agree with Mr. Piccarello, but I have to tonight. You must be aware of Ray Hartz Jr.'s beef with the Ethics Commission, who scheduled an ethics hearing on his complaint while he was out of town. And they charged right ahead without the complainant being present. So there's some room to think that you can do that. But I have to agree with Mr. Piccarello, at minimum, you should amend this motion to the call of the chair. And in the meantime, then contact the complainant and tell them the first continuance was because the reasonable accommodation had not been met. You bent over backward, apparently, tonight to get that accommodation, and that they need to either commit to being here the next time that reasonable accommodation has been made, or she needs to withdraw the case. But you shouldn't just dismiss it. Please amend your motion.
Thank you. Member David.
Just through the chair, question for Victor. Did she confirm that she knew the case was tonight? Like, did you get was there any back and forth between you and...
There was some back and forth, but there was no overt confirmation, but she was aware of today's meeting.
Okay, and there was never a request on her behalf to defer it? Was there any, I guess what I want to know is that could there have been any confusion that from her side that the case was tonight?
I do not believe so.
Okay, then, yeah, I'm willing to. I'm not as the second, or I don't know if I was the second or not, but I'm not withdrawing if I was the second.
Who made the motion and who was the second?
I made the motion.
Member Hyland, Member Rumold.
Okay, all right.
I'm happy to amend the motion to the call of the chair.
Does the second accept?
No, actually, I don't. I think, look, we could reopen it potentially if she comes forward with a legitimate response, like a legitimate reason. But
may I suggest that we table the matter, and I will inform the complainant that we have tabled it, and if she would like to have it reopened, that she would need to let us know.
Point of order. Can a second deny?
Oh my God.
Excuse me, excuse me. We'll work that out, Mr. Minetshaw.
Further discussion?
Member Pilpel.
So I was looking at the back of item 2. I didn't see a notice of tonight's hearing in that item, but I did find elsewhere in the packet, page 98, that there was a general email sent out August 20th at 10:10 that included Ms. DeAnda and referenced that complaint. So I do believe the complainant was notified, and this is the second appearance. Normally, our practice to date has been we'll grant a first continuance, good cause of hearing. Second time, if there are no show, we dismiss it.
I would say that in this case, we don't have an instance where the complainant did not show for the first time, just didn't show. It's just not like the second no-show. This is the first no-show.
Fair enough.
So I personally am not comfortable with simply dismissing it. I think continue it to the call of the chair and make another, given the nature of this case, having read through it, that seems reasonable and it is consistent with what we've done in the past.
So through
Members,
the chair,
Vice Chair,
perhaps we should follow the clerk's suggestion. That keeps it, gives us all the options we need.
Member David?
I'd like to call the question. I'd like us to vote up or down on whether, and then if we vote down, then we can continue it. But there's a motion, and I say let's do an up or down vote on it.
Fair enough.
Mr. Young, would you call the roll, please?
The motion is to...
excuse me, Member Wolf.
It seemed like Member Highland amended the motion, and then it didn't have a second, or I'm confused what the motion is supposed to be.
So this is I'm sorry, through the chair, and this is my understanding is that the original motion is still on the table to dismiss because the second did not agree with the removal. That's my understanding. Is that other people's
That's my understanding.
Yes, that is my understanding.
All right, thank you.
Sure.
Mr. Young, would you call the roll?
The motion is to dismiss the matter. Member Rummel?
Aye.
Rummel, aye. Member Winston absent. Member
No.
Wolf, no. Member Pilpel?
Yes.
Pilpel, aye. Member Hefner?
Aye.
Hefner, aye. Member David?
Aye.
David, aye. Member Fisher?
Aye.
Fisher, aye. Member Oka?
No.
Oka, no. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
No.
Washburn, no. The motion passes by a vote of 6-3.
Mr. Young, is it your practice to inform the complainant about what has happened here?
Yes, I will inform the complainant.
And to let the complainant know that without prejudice, she can
She may
reopen the case.
refile if she would like.
Okay.
And
Thank you.
further, if the complainant shows up during the rest of the meeting, we could always rescind that action and still deal with it tonight, as long as Ms. Soraya is still here. So.
That is a possibility, but I do not believe I believe the ADA accommodations will not be here at that time.
All right. Okay. All right. At this point, I would like to adjourn the meeting recess the meeting for 20 minutes.
And then we'll come back to item 5?
Pardon me?
And then we'll come back on item 5.
Yes. Yes.
Yeah. I hear you. Where was that?
So in the end, they were shot down, knocked down, pushed back.
The September 3rd, 2014 regular meeting of the Sunshine Ordinance Task Force is called back into order at 6:20. Mr. Young, would you call the next item on the agenda?
Item number 5, file number 14054, complaint filed by Philip Carleton against Richard Lee and the Department of Public Health for allegedly violating Sunshine Ordinance Section 67.3, 67.4, 67.7, 67.16, 67.21, and 67.25 for failure to accurately respond to requests for public records in a timely manner and for failure to properly post public meeting agendas and minutes.
Move to find jurisdiction.
Is there a second?
Second.
Has jurisdiction been contested in this matter? Okay, I'd like to move to find jurisdiction without objection.
Public comment?
Oh, okay, I'm sorry. Public comment on jurisdiction?
There is no public comment on jurisdiction.
Right. So without objection, we'll find jurisdiction. At this time, first, the complainant has 5 minutes, up to 5 minutes, to address us and present facts and evidence to support your complaint. Then the Department of Public Health will also have 5 minutes. There may be people here to offer facts and evidence in support of what you say. Sir, Mr. Carlton?
Yes. Good evening, ladies and gentlemen. First, I want to apologize that my complaint did not have the proper address and letter form. Second, I want to state that I did not know that the California Massage Council is a nonprofit organization. I thought it was an agency of the city. I read Mr. Lee's submission of August 27th saying that he maintains that the hearings of the Director of Public Health are passive meetings. I want to make the case that they are a policy body meeting and they should have agendas posted 72 hours before the meeting, and that they should have minutes taken at the meeting. Mr. Lee says it would be difficult because there's sometimes cases that are exceptional, and my response to that would be they can have special meetings. They do not have to have simply one meeting per month. They can have special meetings if they have special cases. Secondly, he says they do not have a secretary. I think it's imperative that they have a secretary for cases that involve the future of a massage parlor establishment, the future of a massage parlor practitioner. If they are found guilty, they can no longer practice be a massage practitioner in the state of California. Let's see. And he has said that you can get recordings. The recordings require sending mail, being sent by mail, making requests, being sent by mail, and then trying to listen. I listened to these recordings 5 times with different players at the University of San Francisco where I work with the Mac, and I could not understand them. The main dispute has been over my request for information. I requested in writing on April the 23rd any reports that he had mentioned to me on April 22nd. I was sent these 2 reports. Upon further review of this one, this is a response to a rebuttal of this report and this slide presentation made by the California Massage Therapy Council. I was sent these two, but Mr. Lee said in his discussion that that this was a presentation made to the California legislature. Only this was sent to me. I waited 43 days. I had to consult the California Massage Therapy Council. They told me there was another document. I had to wait 43 days for them to provide this to me. Also, I requested that they put these reports on the internet. These must have cost hundreds or thousands of dollars to produce. They refused to put them on the internet. I've asked them to put them on the internet and the minutes and the agendas on the internet. This is an age of technology. This is not difficult to do. Next, I requested any documents since the Department of Public Health took over regulation of massage parlors that mentioned the words human trafficking. Mr. Lee had told me back in September, October of last year that there was a case. I wanted to learn about that case. I found that there was simply one case, yet in our newspapers and some of our supervisors have used the word human trafficking excessively, I think. And I think that this shows that there's been one and only one case a proven, documented, prosecuted human trafficking in massage parlors in the city of San Francisco. This document took 34 days to provide. However, it has 100 pages that are irrelevant. There's no mention of human trafficking on them. I'm sorry that they cannot read my request and follow my request. Okay, and the last part of my presentation I want to point out, I have one of the recordings, and I'd like to play it because it's totally incomprehensible. If they refuse to give minutes and agendas, they should at least have recordings that are comprehensible, and this is not comprehensible. You can hear it yourself.
That covers both. Is it 973 young team lead practitioner? Is that? Yeah, well, that's sounds like you heard before. Okay, all right, we're going to go to 3410 Judah Street.
Having trouble sleeping? Can I get a constant?
It's like talking in a barrel.
Underwater.
Wah, wah. Talking in barrel.
Thank you.
The director does not insist upon the people speaking into the microphone have someone monitoring the microphone such that a clear, precise record of the meeting is provided. They refuse to do minutes and agendas 72 hours, and then they provide this kind of stuff. Yeah, okay, I'll stop.
Well, we'll have a chance to ask you questions.
Okay, thank you very much.
Is there anyone here to offer facts and evidence in support of the complainant?
Two
Support of
were here, but they left earlier.
Oh.
They had to go. One had Paul Horcher had to go to a dinner arrangement.
Okay, thank you.
You had Paul Horcher here? Cool. I didn't see him. I was busy working on,
At this time, the respondent, Mr. Lee?
Hi.
You have up to 5 minutes.
Okay, good evening. I don't have that much to say. I think you have my letter from August 27th. And again, I think environmental health, our branch, is actually, consistent in terms of open data, open information. We're one of the first agencies to provide restaurant inspections to the public. We work with the Mayor's Office of Innovation to provide data to Data SF, and we're one of the first agencies to work with Yelp to post our scores on the website. So I think, in general, we always attempt to provide information to the public. But in this case, again, for our director's hearings, I agree with Mr. Carlton, we don't provide agendas and we don't provide minutes. And I think that's going to be very difficult for us. And again, I want to reiterate that we don't think that our director's hearings, because it really just is composed of our health officer who presides, that is not a policy committee and doesn't have to comply have to comply with the Brown Act and the Sunshine Ordinance in terms of having an agenda and minutes. So again, for that point, I'd like to address that. And then for the issues of the CAMTAC presentations that were provided, I'd like to have Cindy Comfort talk about that. But also in the discussions on the stuff that was given to us in terms of the cases, I had actually prepared information about the case for the human trafficking case, and I had that information, but it wasn't actually cited in the documents that I got it, so I don't have that information here. But we would have, if we want, we can have a discussion about that specific request for the one case on human trafficking. Okay, so right now I'd like to have Cindy Comfort talk about the CAMTAC documents.
Thank you.
Good evening. I just want to quickly go over the request.
Name, please.
I'm sorry. My name is Cindy Comerford. I work as a manager of planning and fiscal policy in the environmental health branch, and I've been the staff person who's been working on our massage legislation and our strategic planning for human trafficking for the Department of Public Health. So Mr. Carlton had requested any documents on our massage regulation. I had supplied him with a report that we had done on licensing and regulating massage establishments within San Francisco, and also a response document that I had written to a report from CAMTAC. We gave that to him right away. He responded back to that request that I had to remove pages from the report, which kind of threw me off, and that he was looking for something else. After going through his emails, I was finally able to ascertain that he was looking for a PowerPoint presentation that we had given to the State Assembly 7 to 8 months prior to his request. And as soon as I was able to understand his request better, we immediately gave him that presentation. So because his requests weren't very clear, I wasn't able to respond with the correct documentation. But as soon as we were able to understand what he was requesting, it was immediately released to him.
Thank you. Is there anyone here to offer facts and evidence in support of DPH, the Department of Environmental Health? Okay, seeing none, the matters with the members of the task force. Yes, Member Fisher.
Check, test. Professor Carlton, come on up. I'll make this quick. It's a question I ask many times in this room, especially after what I totally forgot your name already, from Comerford said. Have you received, first of all, I applaud you for what you're doing. I mean, this is our bread and butter right here. When people need information or they're not getting information or making sure the departments...
Excuse me, I'm 69 and I have a hearing loss. Could you please speak very slowly and carefully?
I'm 52 and I have hearing loss. Yeah, Professor, have you gotten everything that you wanted? Are there any other reports, or I just heard of this PowerPoint. Is there anything you're missing? Because I really applaud what you're doing. We want to make sure that you're getting everything. And let me finish. And this happens a lot with departments. They're kind of coming up to speed on sunshine ordinances and what they're supposed to do. So my question, yes or no, do you have everything that you wanted or that you asked for?
Well, I do have the reports, but why it took 43 days to give to me is beyond me. Mr. Lee said it was a PowerPoint presentation. It was part of the presentation that he gave. He said a PowerPoint is not a presentation. A PowerPoint is made up of documents that comprise a presentation. Those documents should be available to every person in California, every person in the United States by the internet, because they are important. They talk about and they discuss human trafficking, which is a big problem. Even the sex workers, I don't know if you read the San Francisco Weekly, one of the sex workers wrote a column recently saying, we want to be involved in all discussions about human trafficking too.
I believe that was Maxine Dugan, correct? I think I read that.
Okay. But one other question. When they had this discussion about Red Book and rub maps, I asked Mr. Lee pointedly, how do you use those documents? He never responded to that question. So that's one question that's not. But it shouldn't take me 43 days to get this. It shouldn't take 51 days for him to tell me this is the one and the only one. I teach English as a second language. The words and the are very confusing to international students and American public and to lawyers. You can say this is the one means the one I told you about. It can mean this is the one and only one I'm going to tell you about. We've got others. It could mean this is the one we found and we're still looking for others. But when you say the one and only one, that means the one and only one. And I shouldn't have to ask several times and wait 51 days for a response for him to talk to his inspectors and to get that information to me. That's important. That's one. So there is one thing that I'm still hoping for him to reply to. I may have to file another immediate disclosure request. I hope not. But he has not answered the question, how do you use that information? In fact, last year, a friend pointed out to me, was reading Red Books, and Red Books, they had a discussion about one of the supervisors now who was at UC Davis, and someone said that this person had had sexual activity with that person and rated that person 8 in looks and body and 6 or 7 in service. Okay? So if red books are being...
This exists.
They need better service.
I can talk to you afterwards about it if you have questions.
I
But
did
the
not know
point
this
is,
existed. Yeah.
if they're using red books, I think it's a highly spurious way of determining guilt or criminality. Because from what I've heard, a lot of it is just nonsense. People bragging and writing nonsense. So I wonder, I want to know how the Department of Public Health uses that information and what validity they give to that information. And all of us should know that. All of us should know that. So that's the one thing that has not been given to me.
Thank you. Thank you, Professor.
Thank you.
Member David.
So I want to, I guess I have a question for DCA Kala. The question about, is it the directors meeting that we were talking about earlier? Is that as to whether that would be considered a public meeting and whether it would need to be agenda
Have to notice, 72-hour notice
Yes.
with an agenda.
Right.
I think that's a great question, and I think you'd have to look at 67.3, and that defines a policy body meeting and then a passive meeting. I think it would be helpful to have the respondents come up and explain what really happens at these directors' meetings, and then determine whether or not that fits within the criteria to be classified as a policy body meeting, which would require more notice and having recorded minutes and advance notice on the agenda. Or is it a passive meeting? Do you think it's not either?
Okay.
So,
please, I'm there. What he asked.
Okay, so again, the director's hearings are really for enforcement, for specific, usually for specific permitted facilities. So usually what happens is that, we have inspectors, they do inspections, they see violations. And then what happens then is if they continue to have that violation, then the enforcement moves up. And it finally comes to a point where there's going to be decisions about either we fine people or we suspend the permits so that they can't operate. So that's what the director's hearing is. It's for cases like, for instance, like if someone was selling, a grocery store was selling tobacco to a minor, which is one of our major cases. And then we found out, there's testimony from the police that says, yeah, they did it. And then the director will make a decision how much time he should suspend that tobacco sales permit so they can't sell tobacco. And then for massage establishment cases, it's similar, where let's say that they had they had massage practitioners who didn't have permits, then we would fine the establishment a certain amount of time because they were using unpermitted practitioners. And that can go anywhere from a couple of days to 90 days to even revocation.
Okay, so this might be perhaps the dumb question of the day. I'm assuming that these meetings are not open to the public?
They are open.
They're open to the public.
They are. So the directors' meetings are open to the public?
Yes. Well, it's like what happens is that all the responsible parties are told of when these hearings are occurring, and they are said, if you want to bring people to support whatever you say, you can do that. So we tell, the main point is that we would tell the people that we're going to enforce against, this is a time for you to explain why you're not in compliance. And a lot of times they can have other people to support them. And then a lot of times we will have other people to support our position too. Like a lot of times we will have police officers there.
Okay. So I have a question to the task force or to DCA COLA. Are there any other bodies that function in this manner where they have meetings that are open to the public but are considered passive and do not need to?
Yes.
Excuse me.
I don't know if they've gone through the process of I don't know if anyone has ever scrutinized any other bodies' similar type of hearings to determine whether or not they're passive, but DBI holds similar hearing. They actually call them directors' hearings, and it's the same process. someone's cited for a violation, they fail to comply within a certain amount of time, and it's just another administrative hearing in the process before it eventually gets referred to the city attorney's office for litigation for failure to comply.
And at these DBI hearings, these directors' hearings, they would also be they are also open to the public. Is that correct?
They are open to the public. I'm not certain as far as the notice requirements or what their process is for notification, but more often than not, whenever a property that's at issue at a violation is noted, they'll post a public notice on the property saying where a hearing date will be.
So can someone answer, and I don't know, Mr. Member Rummel or DCA Cola, what is the standard? What is the legal standard as to whether it is a meeting is passive or not?
Well, that is actually laid out in 67.3. You'd have to determine whether or not you think it's a policy body meeting, which would require heightened. There's a heightened requirement of notice and meeting recordings. Or whether you think it's a passive meeting. So I think given the information that was just provided about this meeting and the contents of these meetings by the respondent, I would suggest looking over 67.3 to determine whether or not you think it fits into one of those categories.
Member Rummold had his hand up.
Yeah, I have a question. Who is on this committee?
There's only one person. It's a representative from the director of health, which is usually the health officer, Dr. Aragon. Just one person making the decision.
And how did the committee come about?
I think it's in. I'm not sure, but I'm pretty sure it has to do with this administrative code that specifies there's to be directors' hearings where people can actually appeal some of their decisions about penalties.
Member Pilpel.
Okay, so I've got 4 areas to explain and ask questions about. First is directors' hearings. Second is the reports that were requested by Mr. Carlton. Third is the internet. And fourth is DPH's procedures for handling public records requests. So as to the director's hearing, let me try to explain that. Many city departments have director's hearings or other types of administrative hearings where either the director, the department head, or a designee holds a hearing. Parties are notified. It involves not just DPH in the ways that Mr. Lee explained, but also restaurant immediate closures for various reasons under environmental health. DPW holds directors' hearings about tree removals and graffiti abatement and all kinds of things. MTA holds hearings about traffic engineering changes. OLSE holds hearings about various things. Okay? They are public. They are not policy bodies because it's not a multi-member body. They're also not passive meeting bodies because, again, it's not a multi-member body. It's a single hearing officer that's hearing evidence and making a decision that in some cases is subject to appeal to the Board of Appeals, in other cases is a final administrative adjudication, but it's a public hearing in a way, but it's not a policy body. They're noticed by way of a notice on the wall. Generally, they're not published on the internet. There's not a mailing list for most of these because they're kind of spur of the moment. The city does not have an Administrative Procedures Act that codifies how these work. It's kind of all over the place. In the case of public health, I assume Alita Van Runkle or various other city attorneys. I forget who usually does environmental health.
Well, right now it's been assigned to Sherry Kaiser.
She's now over on the health team. Okay.
She's doing environmental health now.
Okay.
And you made a good point about this case. I mean, a lot of these cases will go to the Board of Appeals, where there is going to be more of a public.
So the tobacco sales to minors, that frequently gets to the Board of Appeals. Okay, but on this, there is this process for a director's hearing. There could be more transparency in terms of putting a notice on the website so that at least there's something out there. The departments are not consistent about it. It's not something that we could require under the ordinance. It's something that we could suggest, and there's probably a longer discussion about how to make director's hearings more open and transparent. that's kind of enough on director's hearings for the moment. On the reports and the response to the initial request, the way I read the April 23rd request from Mr. Carlton, it was asking at the end, also like access to any reports regarding suspicions, investigations, et cetera, of human trafficking in San Francisco, massage parlors, et cetera, for a period of time. It was a pretty specific request, and it was not, as to form or content or presentation or whatnot. It seems pretty clear, and there was a fair amount of back and forth to clarify what. I certainly think there was a violation as to timeliness, and I guess this kind of goes to my last point about DPH's procedures. When Mr. Lee, as the, I guess, still now acting director, Mr. Bhatia is gone and we haven't, whatever. When you get a request like this, does this not automatically get copied to Ms. Soraya? Is she still here, by the way?
Ms. Soraya.
Yeah, is she still here?
No, she had to leave.
Okay. Is a request like this not copied to her, and is she not tracking public records requests to ensure that there's timely compliance, et cetera, et cetera?
She does.
Okay. Because it did not appear from these emails that they were all copied to her.
This got very confusing because what happened was that originally, can I explain what happens was that I think the original request was that Mr. Carlton gave was he wanted all the files from all the massage establishments.
Right.
That would have been
a lot.
I mean, that would have taken months. And the reason why it takes so long is because we're having the city attorney redact the files.
But it took a while for you to get to that, and then you got to the Broadway thing. And
then we walked through this whole thing about first things. Okay, then we want to know about. Then it got more specific about what case, what he really, and he wanted any case that said specifically human trafficking. So then I talked to my staff. My staff said they only knew of one case where it specifically specified human trafficking, and that's the file that we got. And then we had to send it to the city attorney
to review
to
for
redact,
redaction.
and
Okay.
it took weeks for that.
Okay. At any point in this convoluted back and forth, did either one of you actually pick up the phone and call each other and say, here's what I'm looking for, or what is it that you're looking for? Let's figure this out? Because this.
Yeah, I think it was. I mean, that's what happens was because when I first got the request, I said, oh man, this is impossible.
Okay, but did that actually happen other than by email?
I'm not sure. I don't remember.
Might that have been helpful early on?
I think I must have talked to Ms. Carlton at least once on the phone.
Okay. It just seems like talking to each other would have helped earlier to get information sooner.
Well, I certainly appreciate the fact that it went from information about all massage establishments to just any case that my staff knew about human trafficking, which made it a whole lot easier.
Okay. And then my final point, and I'll shut up for a bit, 67.29-1, I believe, talks about the internet and standards for disclosure. Sorry, -2. And one sentence of it states, each department is encouraged to make publicly available through its worldwide website as much information and as many documents as possible concerning its activities, period, at a minimum, blah, 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 blah. So I don't know if you need to get 500 requests for a particular document or report, but I think Mr. Carlton made a good point that these documents, these reports, are of at least some public interest. You've got lots of reports on the DPH website on not just environmental health, but AIDS surveillance and communicable diseases and public population health and children and all kinds of things, and yet there's really nothing on this particular.
Actually, after we received Mr. Carlton's request,
you put it up.
We put it up.
Cool. All right.
Okay. Right.
I think I'm good for the moment, but I do think at the end of the day that there's at least a timeliness violation, and I think that you and Ms. Soraya, that the department needs to better figure out how to deal with these requests so that things like this that don't need to get that complicated can get resolved and the information can be provided sooner.
Okay.
Thanks.
Members? I have a question for Mr. Lee. We heard the CD recording, the recording of the directors' meeting, and it was incomprehensible.
For certain parts.
Okay.
Yeah.
So one of the provisions, this is a public meeting, that is a public record. There is a provision in the ordinance for maintaining records, public records in a professional manner. So what provisions, I mean, how do you go about creating a record of, given that you don't have a secretary, you don't have minutes, you do have you record them, how do you do that so that you have a recording that's
the most important part for us
audible?
is actually the director's decision. Actually, for every case, the director will make a decision based on what he heard, and there will be a letter produced by and signed by Dr. Aragon on his decision on that case.
All right, I understand that, but
Goes in the
there's
Yeah.
But nonetheless, you have this hearing, and you've been recording these hearings, and someone conceivably, the complainant, Mr. Carlton here, was very interested to know what happened during the hearing, and your recording of it was pretty worthless.
Okay,
so,
I guess maybe there are certain parts. I mean, so I think it all depends on how close someone is to microphone. And unfortunately, a lot of our cases, we will have 4 or 5 people standing there. Some people are lawyers representing them. Sometimes the responsible party will talk. And so a lot of times it's difficult, or we can guess it's common where people will not be standing right in front of the microphone. That's probably the main reason. But I'm sure Dr. Aragon's voice was probably very clear. And if you're this close, it's going to be very clear.
But then
excuse me, Member Pilpel.
But then the hearing officer, just as Chair Washburn and anyone else running a meeting or an event in room 300 across the street, can say, I need you to speak at the microphone. We're on the record. We need to take, okay. And that should be a regular.
And I can remind Dr. Aragon to do that.
And if you need to invest in a better sound system over there,
Sure.
And the commission secretary can, give Mark something to do, right?
Mm-hmm.
Member Wolf.
So I'm still a little confused as to whether these meetings are passive meetings or public meetings or something else. And I'm curious, in your perspective, what's your last name, sir?
Lee.
Mr. Lee, sorry, that's what I thought, but I wanted to make sure I had it right. Would you consider this a public meeting, a passive meeting, or something else in terms of the way that the San Francisco, I guess it's the code, defines these things? So Section 67.4 defines passive meetings, and Section 67.3 essentially, between those two, defines these terms that we're talking about. And in your perspective, which of these two or something else do these directors' hearings fall under?
Okay, I don't have that in front of me, and I'm not familiar with those two definitions. The only thing I can emphasize again is that this is really dealing with specific operators and enforcement of violations on those operators. So, again, I'm not sure if it's meant for the whole general public to hear what's going on about someone who might have violated the health code. But that's what these meetings are. And basically, it's decide the punishment for those specific people, or operators.
Right. I mean, I definitely, you've done a great job of explaining the purpose of the meeting. It's just in terms of parsing this actual code, I have a hard time really understanding where they fall. It doesn't seem like it necessarily meets the definition of a public meeting or a passive meeting body, particularly because it's essentially a one-person committee that's involved in the meeting.
I'm not sure if it's even a committee. I mean, it's just the director making the decision about the penalties.
Does our city attorney representative have any further to weigh in on how we can sort of parse this? Because I'm sort of lost.
Well, given the respondent's description of the director's hearings at DPH, I could read out the definition of a policy body, and if we think if the task force thinks that hearing meets that director's hearings fall under the description of a policy body, then there's a heightened requirement for agenda notification and minutes being recorded. But if it doesn't meet that definition, even if it's just a passive meeting, then that requirement, then there is no such requirement. In that case, there wouldn't be a violation. So under 67.3D, a policy body shall mean, 1, the Board of Supervisors, which this isn't, any other board or commission enumerated in the charter. 3, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. 4, any advisory board, commission, committee, or body created by the initiative of a policy body. 5, any standing committee of a policy body irrespective of its composition. 6, policy body shall not include a committee which consists solely of employees of the City and County of San Francisco unless such committee was established by charter or by ordinance or resolution of the Board of Supervisors. And 7, any advisory board, commission, committee, or council created by federal, state, or local grant whose members are appointed by city officials, employees, or agents. Now, based on those 7 characteristics right there, if you don't think a director's hearing falls within that, then there's no meeting violation with respect to the complainant's complaint.
Vice Chair Hyland?
To restate Member Wolf's question, what do you think?
That's for you guys to make up, not me.
What's your esteemed opinion?
This is a passive meeting at best.
Thank you.
I actually think it's something else altogether. I think it's neither a policy body nor a passive meeting body. It's some other animal.
So, Section 67.4A, if you want to look that over, if you determine that this is a passive meeting at most, then all gatherings of passive meeting bodies shall be accessible to individuals upon inquiry and to the extent possible consistent with the facilities in which they occur. So such gatherings need not be formally noticed. That's 67.1A, how it leads off.
Member Wolf.
I started this off by asking Member Lee where he would categorize these directors' hearings, and you felt that you didn't have the information. I feel that our city attorney representative has now provided that information. Can you make an argument as to which of those you should fit into and why?
I think the DCA actually pointed out there was a specific exemption saying that if it's only members of one department, that it would not be a policy committee.
Member Rummel.
But then, so that one has the comma, unless such committee was established by charter or by ordinance or resolution of the Board of Supervisors, right? Then you say this was established through some part of the admin code?
And I don't have it in front of me. I know that, let's say, for us, a lot of times it's the California Retail Food Code. There are specific sections about a director's hearing. Okay, but in terms of the San Francisco Municipal Code, I would have to look into that.
Member Pilpel.
So, again, to be clear, in this case, it's generally the San Francisco Health Code. There are various other codes that have certain provisions depending on what it is. There are also directors' hearings about garbage things in an uncodified ordinance, but this stuff is pretty much in the Health Code. Chapter 29 and various other chapters of the Health Code, depending on the things. So tobacco control is in one section, and massage establishments are in Article 29. Whatever, it's kind of all over the place. Right. And in general, as I said earlier, a director's hearing is not a policy body, and it's not a passive meeting body. It's another thing.
Why?
What?
But why?
Because it doesn't meet the definition of a policy body. A policy body is a multi-member body that's set up in law. This is a single hearing officer that's doing a hearing officer thing. It's not
developing policy.
But it's not just policy. It's not acting in ways that boards and commissions and bodies like us do, nor is it a passive meeting body that meets to advise the director on policy and fiscal issues. It's actually sort of an adjudicator on under the law. So
if I could, where in the law is it a requirement that a policy body has to be multi-membered?
It says it.
I mean, I'm looking at the definitions, and I don't.
Okay, I have.
In 67.3,
Okay.
67.4?
Yeah. Ms. Comfort said it's in the Brown Act. And I have something here from the City Attorney's Good Government Guide that says, again, it's in the letter I sent you. Because a policy or passive meeting body must consist of 2 or more members, an individual can be neither a policy body nor a passive meeting body.
It has to have 2. Okay.
We're looking for that in the new Good Government Guide. Apparently, your office just put out a new version of the Good Government Guide like today. Did you know that? No.
I don't cite to the Good Government Guide in my memos.
Okay.
Good.
FYI.
You know,
Good for you.
I don't have a firm sense one way or another on this. I'm basing it solely on what the ordinance says, and there's nothing in the ordinance itself that I see requiring, for a policy body to have multiple members. But if there's something else, I'd certainly be interested to hear. And I know you've kind of punted on this a few times.
I believe most public meetings have to follow the Brown Act.
Right.
And within the Brown Act, it defines what a policy committee is. It's a legislative body, and it has to have multiple members for
Right,
more
but
than one city agency.
But then the ordinance also has its own definition of a policy body with its own requirements that are built on top of that. So I don't have a firm feeling, and I feel like I'm just delaying things by throwing a wrench in it. So
I just wanted to mention that it's the last entry actually of the definitions, and there are 7 different types of policy bodies listed, and these are all multi-member bodies.
Well, not necessarily is
Not going forward.
So I would agree that 6 would apply unless, so policy bodies shall not include a committee which consists solely of employees of the city and county of San Francisco. But then there's that comma that unless such committee was established by charter, by ordinance, or resolution.
Member Hebner.
Yeah, it's just while we're on that point, Section C4 it defines passive meeting body shall not include a committee that consists solely of employees of the city and county of San Francisco, created by the initiative of a member of a policy body, the mayor, or a department head. So reading that in conjunction with D6, those are hard to reconcile. It's almost like everything is a policy body or everything's a passive meeting body. I don't think that the number of people on the body should be determinative here. I think that for what we're doing, and understanding that there may be a definition of legislative body in the Brown Act that says 2 or more are multi-members, and I think that's a separate definition. But what we're doing should be from a policy perspective. What is going on at this meeting? Is what goes on at that meeting important enough, and should that be made public? Should that be accessible? I know that this meeting is open to the public. Is that enough? I think that that's the question we should be grappling with, is not, how many people need to be on it, but whether decisions are being made there that necessitate that audio recordings be made so that, individuals like our complainant here can get to the bottom of why decisions were being made.
I have another question I'm thinking about the massage parlor. You have a lot of cases regarding this. Mm-hmm. So when there's a hearing regarding a particular establishment, massage parlor, who is noticed about that hearing's going to happen?
The responsible party.
So those would be the parties in interest. What about neighbors?
Not usually. No.
Okay.
I would think it would be a good thing that I know for DBI sometimes neighbors, they're the public notices, you get them, or you may get something in the mail actually. So this seems analogous, and perhaps even weightier things are being determined. Member Pilpel.
So this is an example of where different entities do different things and have different requirements accordingly. So if you're noticing a food establishment, is it called a food establishment or a retail food whatever, a food establishment, and one of your inspectors went out and found a cockroach infestation, like Toulon, for example, which was a pretty high-profile case. You immediately put a notice on the property that says, by order of the Director of Health, this is being suspended, and there's a revocation hearing tomorrow morning at 9 a.m. or whatever. Okay. But there's a process for that thing that depends on the particulars of the order and the law in effect. If a thing is subject to appeal at the Board of Appeals, if it's a property-based thing, then generally there's a 150 or 300-foot radius notification because it's a property-related thing. But if it's a massage establishment may not be subject to those same rules. It depends on the specifics of the law that's being enforced. That's why this whole hearing officer concept is very specific to enforcement of that particular law. And I'm sorry, I'm just getting a little too exercised.
That's
here,
true. We don't post notices of directors' hearings. I mean, it's just the responsible party is told they have to come to the director's hearing.
But in some cases, it is posted on the establishment, depending on the thing.
Well, not for the director's hearing. All we post is that it's closed. All times. Okay, we don't say there's a director's hearing. There's going to be a hearing that people can come to. We don't do that.
So if we thought that there should be a posting at the location at issue, we could recommend to the Board of Supervisors that that article of the Health Code be amended to require a posting there. But as it is, this whole area of administrative hearings is really not something that's governed by the ordinance. It's just not. If the supervisors or the voters wanted to specifically cover administrative hearings either as a policy body, as a passive meeting body, or as something else, they could have and didn't. And so right now it's not regulated by the Sunshine Ordinance except to the extent that there are records created which are public and available for on request. Thank you.
Member Wolf, and then Vice Chair Hyland.
I think Member Popol is kind of on the right track here in that it seems like we have a type of meeting that is not a policy body meeting. It definitely doesn't qualify as a meeting under the Brown Act because it doesn't have two members. Most of the definitions around this are at least built upon the Brown Act, even if they're not inclusive of it. And it seems like we have this new class of public meetings. They're public meetings that aren't governed by, as best I can tell, any Sunshine Act or any state public records law, which then kind of defaults that even though that recording is hard to hear, I don't think there's any governance about the requirements to record it in the first place or do a good job of recording if they are recording. And it seems like this is really pointing out a need for additional legislation around how these public meetings should be handled and what rights the public has in regards to them. But I just don't see anything to support that in the existing law.
Vice Chair Hyland.
I think being mindful of the time that we've already spent on this case, I think maybe we should focus more on the clear-cut violations of the Sunshine. And to that end, I wanted to focus on 67, 21, and 25, and perhaps get a motion out.
We need to hear the rebuttals.
Okay. But that's where I'm leading this point.
Is there anything else, members? Okay. At this time, Mr. Lee?
Yeah.
You have an opportunity now for up to 3 minutes for some closing remarks, a rebuttal. Anything additional you want to add?
In regards to the, I guess the inability to provide the information on those reports, we would say yes, we did. We're gonna try to do better. I think part of it had to do with there was a miscommunication about exactly what's requested, and for that specific documentation for the posting on the web, we corrected it as soon as possible. In terms of the issue about the one case on human trafficking, That's the issue we have a lot of times with the city attorney being able to get a response from them quick enough. And that's something we would have to work on, because a lot of times we don't control how quickly the city attorney can do their work.
Thank you.
Okay.
At this time, the complainant, you have up to 3 minutes.
Okay, first of all, I think it is a policy body because it's not one person. There's always the staff of DPH and police department staff who come and report to them. So it's not really one person. Secondly, I think that all the notices, the agenda that are provided should legitimate these meetings. They should say, by what ordinance, by what directive are you holding this meeting? Secondly, they should point out a means of appeal. If they do not provide a good recording or minutes, how can those people who want to appeal it, and the method of appeal should be stated clearly. And that is not done at this point. Now, whoever's the director should say, one person talks at a time. You talk slowly and carefully so Mr. Carlton can understand you. And you speak into the microphone. And if that is not followed, then the director and the staff of DPH are responsible. And they should be given a $1,000 administrative fine like they slap on the massage parlors for violations. So let's see, what else I think. And I still resent the fact that Mr. Lee said in his original remark, we will send you the presentation. He sent me 8 pages. He did not send me the full presentation. I don't know if that was intentional, or if he's directed by others, by Supervisor Tang or somebody else, not to provide that to the public, but it should be on the public website. And I begged him to put it on there several times. And he refused to do it. Now you have gotten him to do it. Thank goodness. The people pay money for that. Everyone should see what is happening in terms of human trafficking and the violations that are happening in our massage parlors. So my concern is I think it is a policy board. They make decisions that affect the lives and the businesses. You close down a business for 30 days or 60 days, the ladies, the owner gets no income. The massage practitioners get no income because of the violation of one person. That should be stated, minutes should be taken, and the fact that it says we can't do it, that's not an excuse. They should do it, in my opinion, because we need a clear, evident public record for appeals, and the appeal process should be stated in the minutes. Probably think of other things to say, but anyway, thank you very much for your time and your consideration.
Thank you. The matter is now with the task force.
Baby, one more thing. I can't understand why they couldn't find a document. There's 100 pages of nonsense, and I ask only pages that mention human trafficking or some language equivalent to that. Why would they waste 100 pages giving me things about the department? 1999, when they were not even in charge of this establishment. They took charge of the establishment, and I asked for everything since you took over, which was in 2004. So I don't understand why they can't follow the requests of the public. Thank you, ma'am.
Thank you. The matter is now with the task force. Member Pilpel?
Member Highland, did you want to make the motion?
Vice Chair Highland?
Oh, go ahead.
Member Pilpel?
Well, while you're crafting it, and I'm happy to second it, to Mr. Lee, the name I was trying to remember was Cecilia Mangoba.
You're right.
Okay. And it's actually section 29.22 and 29.27 of the Health Code that provides for directors' hearings for establishment of a massage establishment and enforcement hearing based on notice and the opportunity to be heard where there's an alleged violation. So it's all laid out in the code on this thing, and each separate code
Each
section.
separate health code, right, could have it.
Right. So, and that's why I said there's no consistency and uniformity to how the city handles administrative hearings.
Okay.
It's kind of a mess.
Is it possible to respond to Mr. Carlton's rebuttal?
We've actually moved on to a consideration of a motion in this matter.
Okay.
Member Highland, I'm happy to second the motion you're about to make.
Well, I'm looking at sections 67, 21, and 25 that cover responses and timeliness. I'm happy to entertain.
I don't know if any of these were immediate disclosure requests. I think they were
I think
not.
the last one was.
One was? Okay.
There's 3 different requests, so that covers all of them. I think the last one was, yeah.
I think 21A and 25A does it. Let's see. Excuse me, 21B and 25A.
Is where I was going with those 2.
You want me to make it instead?
Sure, yeah, go ahead.
All right. So I'll move to find a violation of 67.21B and 67.25A for DPH's failure to respond to a request for public records in a timely manner, period.
Second.
Member Rummold.
So that's fine with me. I just had one request, though, of City Attorney Kala, and that is that if you could, I know you don't want to kind of stake out a position tonight on whether a director's meeting is a passive meeting body or not, or a policy body. But if you could take a look around the city attorney's, I don't know, what you can disclose to us, but if there's some opinion that it already exists, I can't imagine we're like breaking ground here with considering whether or not a director's meeting is a passive meeting body or a policy body. I'd just be very interested to see that, if that opinion exists, if you can share it with us, and if you had any other insight, I would be interested to see that.
If one exists, it would probably be with DPH's advice council. I can ask them, and that would probably be a matter of public record as well, unless it was, well, it might not be, but if it does exist, they can ask DPH for permission to release that as a public record.
Right.
I can ask.
These directors' hearings happen, it sounds like they happen across city agencies. So
Lots of city agencies have them, yeah.
Yeah, so I mean, I'd be surprised if it hasn't been looked at some point. So I would just be interested in knowing if there was anything.
Member Wolf.
Member Hepner actually had his hand up first.
Oh, I'm sorry. Member Hepner, then Member Wolf.
Just on that point, the city attorney released its new good government guide today, and there is a section on individuals that says that a policy or passive meeting body must consist of 2 or more members. So I'm assuming that's the city attorney's position on it. There's not a site there, and my brief digging around right now, I don't see any justification for that position. But maybe that's something that we could, that would be a good starting point. Just the justification for the city attorney's position on that.
Member Wolf.
And just sort of continuing that thread, I don't know whether there would be any case law around this issue, but if there was, that obviously would be helpful to. I didn't know that you would check for a case law and that sort of thing, but all right, I guess there isn't.
Member Pilkall.
I guess since Marie Blitz recently retired, really the best person to go to is Buck, and I would inquire if there are any written opinions on the question of both the, to some extent, the authority of a hearing officer and what sunshine or open meeting requirements, if any, apply to administrative hearings. Because this isn't really, it's new for us, but it's not really a new topic in city government. And, Buck would certainly remember, because that's what he does.
There's a bit of an ethical wall there, but I don't
know how. I think the ethical wall is only to advise the task force to inquire about what city attorney opinions exist. I think you can ask that. No?
It's a slippery slope asking any question to someone that I have an ethical wall up against about sunshine matters in general.
Well, how do you get access to city attorney opinions? I mean, if there's
There are certain people that I can reach out to.
Okay.
So I'll reach out to their channels of B.
I mean, if there's a George Agnost opinion from 1983, let's go. I mean, right?
I just wanted to say no one brought up the matter of the quality of the recordings from what is, even though it's not a passive meeting body or a public meeting body, it's nonetheless a public meeting. And also the issue of internet access to documents, particularly reports that were funded and pertain to public issues about which there would undoubtedly be some general interest. And I think these are important issues that could be addressed in, say, the EOT. So do I hear a motion to find violations of either 67.29-7A or 67.29-2?
I referenced the 29-2. I'm not sure that there's enough to find a violation, but if the motion to find the other violations passes and this goes to EOT, we could certainly have a broader discussion and perhaps suggest to Mr. Lee that the Health Commission take up the issue of what reports should be posted on the website and sort of broaden the disclosure of interesting reports from what it's been now. I mean, environmental health does a lot, and you only sort of hear about them when there's some, big hubbub, rather than their day-to-day work, which actually protects us all.
I spent some time yesterday looking at the DPH website and environmental health in particular, and I've been aware of a lot of the work that's environmental health's done through my profession, but I found it's so difficult to find anything at DPH's website. And it was also mystified as to why it looks so different from, there's like nothing user-friendly about it. Doesn't resemble any other website in the city, and I don't know. I think we could do a lot better job. But do I hear anybody willing to put forth a motion to find a violation of 67.29-2?
Again, I don't think it's a violation, but I think we can talk about it.
So moved. We could do this as a separate motion.
All right, that's cool.
Is there a second? Internet access for reports. Okay, seeing no second. So we have a motion before us to find a violation of 67.21B and 67.25A. Public comment on these? On this motion? Okay, seeing none. Mr. Young, would you call the roll, please?
On the motion to find violation of 67.21B and 67.25A, Member Rummel.
Aye.
Rummel, aye. Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher. Aye. Fisher, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes.
So I'd like this to go to EOT. And maybe the chair of the EOT would keep in mind some of the other issues that came up.
Do you have any specific instructions to the committee?
To review the procedures for helping people making public records requests and being helpful and making sure that this type of thing doesn't happen in the future.
Thank you.
Would you call the next item on the agenda?
Next on the agenda is item number 6, file number 14046, complaint filed by Hope Johnson against Supervisors Katie Tang and Norman Yee, San Francisco Board of Supervisors, for allegedly violating Sunshine Ordinance Section 67.30 and 67.7 for failure to appoint a member to the Sunshine Ordinance Task Force with a physical disability and failure to provide an adequate description of each item for the Rules Committee meeting.
All right, at this time, has jurisdiction been contested here? All right, do I have a motion to find jurisdiction?
So moved.
Second? Do we have a second?
Second.
Okay, public comment on jurisdiction on this item? Okay, seeing none, without objection. All right, at this time, the complainant has up to 5 minutes. And as former chair of this body, you know how this goes. It's good to see you again.
Okay, my name is Hope Johnson, for those of you who aren't familiar with me from being on the task force. I want to start out, I think the complaint is pretty straightforward, and I don't think I have to do a lot of explanation because I did a lot in my writing, and in fact, most of you were present at the meeting. But I do want to point out that the Deputy City Attorney's memo to you on page 314 of your packet and on page 5 of the attorney memo says that it asks the question of why this is ripe, considering that there is a member with a disability on the current task force. And I want to take a moment to remind you, this is not about the current makeup of the task force. This is about the makeup of the task force as it existed on the day I filed my complaint. I mean, at the time of when I filed the complaint, which was May 15th, not current. 6730 requires that at least one member of the task force be from the disability community. And during the Rules Committee, they made no effort to determine if anybody that was going to be appointed from the disability community. Considering that the task force had recently been unable to meet for several months because no member had been appointed, they had a duty to address that issue. They didn't even ask if the current member would be willing to hold over. And so that is a violation of that requirement, considering that the task force has been hindered repeatedly and that there exists at City Hall, a culture of hostility toward this task force. And that was one more step. And you could have, you had to wait until the following task force meeting to find out if you could even meet. And that is not the supervisors fulfilling their duty as at the Rules Committee. I think that in addition to that, and again, I'd like to point out this is not about Member Oka, who fulfills that role. This is about that the supervisors didn't make sure that that role would be filled so that the task force could meet. And they have a duty to do that. Along the same lines, 67.7A requires a meaningful description on the agenda, and they listed every single requirement that the task force has with the exception of the disability community member, even though that's the one that might hinder the task force from meeting. Now, I know that in the response, they say that it's not attached to a particular numbered seat, but I'll remind you that the seats are not numbered in the ordinance. It's totally random. They assign the numbers themselves, and just because they chose to leave that particular one off doesn't mean that it's not important. And I don't think that this task force should let them cherry pick how the descriptions are made. And the reason that that is important is because there's a culture of hostility toward this task force. And I'm going to give you a couple examples of that. And one of them is that the Board of Supervisors for 2 years refused to appoint the Society of Professional Journalists attorney and the journalist seats for 2 years. Now, they claim that's because of the 6-vote rule. However, I will remind you that the 2 members of the SPJ that were appointed voted no on that rule. So that their reasoning doesn't hold water. It's just pure hostility. They were punishing people for no reason. They had voted no on that. You can look that up. Secondly, at the meeting, because I brought this up at the Board of Supervisors meeting, Supervisor Breed purposely misled the public by saying that the task force didn't have regular meeting days. She basically outright lied. And it was to cover for another member's really, really poor attendance record who they wanted to have appointed again. If they want to appoint them again, that's fine. But the culture of hostility that allows them to just say whatever they want about the task force should end, and they should not be allowed to just pick what they want to put on their agenda description. They should have to include the disability member requirement on the agenda description, and the best evidence of that is that they themselves didn't even realize, the Rules Committee members didn't even realize that that would be something that would prevent the task force from meeting. When they responded to my complaint, they said they didn't think that would happen, even though it had already happened. And also, the Supervisor Campos had to ask the DCA 3 times at the June 5th meeting if you guys had been advised that you couldn't meet before he would answer.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none, is there someone here to represent the 2 supervisors named in the complaint? Okay, you have up to 5 minutes.
Hi, good evening, task force members. I'm Jen Lowe, and I'll be representing the Office of Supervisor Norman Yee. We stand by our original response that we find the allegations filed by Ms. Johnson to be unfounded. The first complaint alleges that Supervisors Yee and Tang violated Section 67.30 by failing to appoint a member with a disability to the task force and not demonstrating a plan to do so. However, as you can see today, the Sunshine Ordinance Task Force is still able to meet and operate. There is currently a member with a disability still seated. Member Bruce Oka graciously offered to serve as a holdover until a successor is chosen, and that was also the same case on May 15th. The Rules Committee and the Board of Supervisors is committed to finding a successor and has actively been recruiting applicants for the seat as detailed by the communications provided in your packet. Therefore, we do not believe that we are in violation of this section. We also dispute the claim that we are in violation of Administrative Code Section 67.7A and B, alleging that Supervisors Tang and Yee failed to include information regarding the disability requirement and did not notify members and advocates of the disability community and their interests that might be affected by this item. First and foremost, the agenda on May 15, 2014 did meet the requirements as it was published 72 hours before the meeting and contained a description about what would be discussed for item number 3, appointments to the Sunshine Ordinance Task Force. It also specified the requirements and term dates for every specific vacant seat. In accordance to that section, the agenda packet also includes disclosures regarding the disability requirement and all applications included. The disability requirement is also clearly indicated on all the vacancy notices. These vacancy notices were sent to the Mayor's Office of Disability, which were then shared through their networks to those in the disabled and advocacy community. This demonstrates that we made an active attempt to inform the community. A representative from the clerk of the board is available today to answer any clarifying questions on this issue. So we really hope that with this information provided that you will choose to dismiss these complaints. Thank you.
Thank you. Is there anyone else here to speak for the supervisors?
Good evening, members of the task force. My name is Deanna Kizan. I'm here on behalf of the Office of Supervisor Katie Tang. Thank you for hearing this matter today. Our office would like to restate its position that the allegation that our office violated Administrative Code Section 67.30A is without merit. Although the Rules Committee did not recommend to the full board any candidate with a disability at a hearing on May 15, 2014, we dispute that the actions left the task force without a designated required member with a disability and without the ability to hold meetings. At the time, member Bruce Oka continued to serve as a holdover, which allows an appointed public officer to continue to discharge the duties of his or her office until he or she vacates formally or a successor assumes the role. Mr. Oka continues to serve on the task force, allowing the task force to continue to hold meetings as evidenced by today. Regarding the alleged violation of Administrative Code Section 67A and B, our office defers to the clerk's office and Chair Norman Yee's office, as their offices have direct oversight over the preparation, content, and posting of the agenda. Thank you very much.
Thank you. Is there anyone here to offer facts and evidence in support of the respondent?
Good evening, everyone. Rick Caldera, Legislative Deputy, on behalf of the Clerk of the Board. I'm here just to talk briefly about, and first and foremost, to concur with the initial response submitted by Supervisors Yee's and Tang's offices. The Clerk of the Board wants to make it very clear that the floating requirement was clearly indicated on the vacancy notice soliciting applications, which was posted on February 7th, 2014. And I'm sure you guys have a copy of it, but I brought a copy for you. Additionally, the information sheet which was included in the packet materials for this item clearly indicated the requirement for the physical handicapped floating requirement. Additionally, the Clerk of the Board and the Rules Committee Clerk both contacted the Mayor's Office on Disability to get their assistance to solicit applicants, and therefore, pursuant to Admin Code 67.7AB, the descriptions on the rules agenda and the backup materials for this matter were meaningful and sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item. And I'm here to answer any questions. Victor.
Okay, the matters with the task force, and Member David has had his hand up for some time.
What are you pointing to?
Victor. It's the back of the packet.
All right. So it is my recollection at both the Rules Committee and at the Board of Supervisors that the Rules Committee asked the city attorney if the task force would be able to meet with a holdover placement for the handicap position, and that the answer was yes. And I believe that Member Oka was actually at the Rules Committee and was.
Excuse me.
Someone scream? What happened?
No,
not on that particular day. Don't believe.
Anyway, my point is that I know that the question, I remember, what I remember is that Mr. Oka had said publicly that he would be willing to remain on the task force until a replacement was found for him. Am I correct about that?
That's correct.
Okay. Are people just allowed to yell out from the audience?
Excuse me, do you have a question for someone?
No, I'm trying to recall what the, am I not
Okay,
allowed?
no.
I thought it's with the task force for discussion.
Okay, no,
Am I
that's
only
fine.
allowed to ask questions?
No,
or am I
no,
allowed
that's
to have
fine,
dis-
that's
Okay,
fine.
thank you. So that the city attorney was asked at two different meetings if a holdover was still part of the task force, would the task force be able to meet? And both times, the city attorney said yes. So I'm not sure what the issue is here. We have Mr. Oka saying publicly that he's willing to serve until another person is found. And, if we want to talk about cherry picking information, like that's, some of the information that was presented tonight was certainly cherry picked and not given in the appropriate order that at least I remember it being done in. So, I don't see any violation here at all. I'm not even sure what this issue is doing, what we're doing with this issue.
Vice Chair Hyland.
I just wanted to weigh in for some of the newer members. When I first joined this committee 2.5 years ago, we did have an issue with a disabled member not being present, and it effectively crippled us, and we decided that we could not meet. And I remember Supervisor Campos coming up before us and talking about that, and I still believe him to this day that that was not intentional. However, I think this is an issue that we need to look at in the Rules Committee to maybe reword that. I don't know if we can do it at that level or higher, but I think this is an unintended way of handcuffing this committee, and I think we need to remove that. in some shape or form. And I believe at the base, this is what former Chairperson Johnson is calling out. And I think we need to hear the merits of this case, but also find a way to go past that and remove this loaded gun, basically. So that's something worth thinking about.
Excuse me, go ahead, Member Fisher. I'm just not sure what you mean by taking what to the Rules Committee and
then I'll speak.
Basically, that additional qualification, at all times, the task force shall include at least one member who shall be a member of the public and who is physically handicapped. I think that was written by the founders of the charter, and I'd love to have them in the room to, be inclusive. I don't think it was intended to potentially shut us down, if the Board of Supervisors and the Rules Committee failed to elect such a person. So that just, maybe that's outside the merits of this case, but that's something I'd like to, have the appropriate body discuss a possible rewording of that to.
That's actually part of the ordinance, so it's nothing that we could do. It's in 6730A.
So that's something we'll go back to the voters. But I mean, it's just a question of rewording it.
Well,
Chair Washburn.
Yes, Member Fisher.
Ms. Johnson, are you there? Back there? I can't see. I'm sorry to ask this, but thank you for coming. It's good to see you, and it's good that this is brought up. I think I'm sort of in a way either disagreeing or veering off the path of my colleague, Vice Chair Hyland. It's in the charter. I think it's a very important part of the charter, and I don't think it should ever be removed from the charter.
That's not what I said.
Then I also did not understand what you said, so I apologize for that. So I'm just curious why we're hearing this case now, Member.
Because on the meeting on May 15th, Member Oka was not present.
Okay. This wasn't rhetorical.
He was present on June 5th, but that is not what my complaint is about. And on May 15th, Member Oka was not present. Nobody asked. One person mentioned the disability, one person, and that was Bruce Wolf, who is an applicant. Now, this is not about Member Oka. I have no problem with Member Oka serving on this, but I do have a problem with you discussing the meeting that is clearly not what I have this complaint about. It was on May 15th, and also Deputy City Attorney Givner told David Campos that, yes, indeed, your committee had been told that you might be in violation and that you had chosen not to meet. And he also said, but that was before they consulted with us, which, as you just heard your own deputy city attorney say, he's not supposed to consult with us. That's why I'm here. That's why you're here.
So is this really, pardon the pun, but are you bringing this up to kind of put some sunshine on this issue and change something going forward? Are we looking back? I'm not sure what you're asking for.
Because beyond this, it is important that you take a stand and that this task force tell the Board of Supervisors that you expect them to address every single requirement, especially in light of the fact that you had not been able to meet, which is contributing to the backlog that exists right now. And at the time, not only was Member Oka not present, he had made no other comment about whether he wanted to serve as a holdover other than to ask David Chu repeatedly in the emails that I gave you to pull him off the task force. So I think that the supervisors, whether it was, at this point it was Tang and Yi, but if other people had been assigned, whoever is assigned to the Rules Committee, the Rules Committee has a duty to discuss all of that there because it's the only time the public can comment on it. Once it goes off to the Board of Supervisors, the public has to be silent. So they have a duty to cover every single aspect so that the public can focus on it. And they themselves, if the agenda was so meaningful, then why didn't they themselves know that they needed to talk about it? And I guess your question is, what do I expect from this? I think that you should inform them that this is a requirement that should be addressed every time it comes up. And it was not addressed. If they had, perhaps I would not have brought the complaint if they had even bothered to take the time to say, does anybody know if the disability member would be holding over in light of the fact that the task force couldn't meet? But nobody even brought it up. Nobody even mentioned it. And when they actually sent the 3 names over to the Board of Supervisors, they didn't even ask if the task force could meet. They didn't even discuss it. And part of the reason is because it wasn't on the agenda. If it had been on the agenda, maybe they would have felt the need to address it. And I think you need to point out to them, because on June 5th, when the agenda was posted again, they left it off again. And they'll continue to leave it off. And the Office of Disability Communication and a vacancy notice, that's not the agenda. The Sunshine Ordinance talks about the agenda, not the attachments, the agenda itself.
Okay, thank you.
First Member Oka and then Vice Chair Hyland.
Yes, Ms. Johnson, are you claiming that I was not a member of this task force on May 15th?
No, I'm saying that the Rules Committee was trying to determine, your seat was up. Your term had ended.
Yes.
And so I'm not saying you were not a member, but that meeting was held to fill the seats. And it just so happens that you happen to be the member that fulfills the requirement that a person from the disability community serve on the seat. So the rule, it's not about the makeup of the task force. The Rules Committee has a duty to this task force to fill its seats, which it had failed in many other ways. But here was one that it was doing right then, right after the task force had been unable to meet.
Was Bruce Wolf at the meeting on May 15th?
Yes.
If he was also an applicant. He was also an applicant for this seat.
Yes.
So what's the violation?
He was an applicant for this. They didn't address it. Even though he was an applicant there, nobody said anything about filling that requirement. They denied Bruce Wolf, but nobody said anything. They didn't say we're not going to appoint Bruce Wolf to the disability seat. They just said we're not going to appoint Bruce Wolf because of the 6-vote rule. There was no mention made of fulfilling the disability requirement, and the disability requirement had hindered the task force for months in meeting. So it is not about whether they didn't. At the end of the day, they did not know. They had no confirmation from you that you would act as a holdover. They had not. Do you have it?
Months before.
I don't have.
Here until replaced. That has been made very clear from the beginning.
Well, I have emails from you that state that you want off the task force.
Yes.
So I think the supervisors had a duty to address that. They had a duty to say, we need to know if this person will hold over because your seat was empty. And this might not come up if the task force had not been able to meet for months. This is not an issue of randomness. This is an issue of the supervisors having this backlog. They say that the task force is ineffective. They say that the meetings last a long time. But they spent 2 years not filling 2 of the seats. And now here is another issue where they failed to address that this requirement existed and that they needed to find out. They didn't even say, we understand this requirement exists and we're going to inquire about it. There was no mention made of it, 0 mention. And that is my point. It isn't about what happened after. And I don't see any evidence other than your emails that you didn't want to be on the task force. I'm not saying you didn't want to be there, that you wouldn't be a holdover, but they made no effort to find out if that was true. And that's their job as members of the Rules Committee. And the public has a right to speak about it, which they don't at the Board of Supervisors, and then they didn't at the Rules Committee because it wasn't on the agenda and people were not alerted that that's where they would have the opportunity to speak about it.
I respectfully disagree with your assertion because the Board of Supervisors, the Rules Committee, knew that I would serve as a holdover until replaced.
What evidence do we have of that?
I told them that, and I've been asked that by every member of the Rules Committee, and I've said that publicly. I will serve until replaced. Yes, I want off. There's no question about that. But I will serve until replaced. Everybody knows that.
There was no mention made of I'm just going to say it again, there was no mention made of how the disability requirement would be fulfilled. The supervisors made no mention of knowing anything about it. They didn't know anything about it, and at the end of the meeting, people were confused about the disability requirement. People wondered if you were going to show up here.
Who are you claiming didn't know anything about it?
Is there anybody here who didn't know anything about it?
I didn't, and the reason is you didn't apply until June 4th.
Excuse me, why don't you just shout it out from the cab?
So I'm not. This isn't about the integrity of Member Oka, and this isn't about the integrity of whether he would serve as a holdover. If they had even said we're going to ask him about a holdover, to me that would have made a big difference. Or anybody else, someone I didn't even know, it would have made a big difference. But the fact that they didn't even address it after the task force had not been able to meet is a big deal.
Okay, Vice Chair Hyland and then Member Wolf.
Ms. Johnson, just stay there a second if you would. Correct me if I'm wrong, but I think... Sure, yeah, no problem. I think what former Chair Johnson is trying to get in the record, for want of a better word, is a message, a formal message to the future Rules Committees that this issue should be front and center every time. That's what I'm getting out of this. And
it should be included.
I applaud her for doing this. Think of if Ms. Member Oka had not stayed on. We may not have met for the last 4 or 5 months, like we didn't 2 years ago. It's an Achilles heel, and that's what I was trying to get to when I was referring to what was in the ordinance. But I think the strongest way we can protect ourselves and this committee and its future functioning is to send that message, to formalize that message to future Rules Committees and the Board of Supervisors. And I, for one, applaud what you're trying to do here. Yes, you're calling them out on technicality, but I think it needs to be done. So that's my position on this.
Member Wolf.
So, what former Chair Johnson raises in terms of issues, I think, are very much on target, but it feels to me like there's a technicality that it wasn't a sunshine violation because Member Oka never ceased to be the holdover. So because he stayed as the holdover, had he resigned at that meeting, then it would have created a violation. But even though they had a duty to fill that seat because Oka hadn't applied and there was an applicant that did have a disability, it sort of feels like they narrowly avoided an actual violation because the seat remained filled and therefore maintaining on the face of it the requirements of the Sunshine Ordinance.
Member Pelpel.
Thanks. Several things. Looking at Prop G, 1999, the prior language was, at all times, the task force shall include at least one member who shall be a member of the public who is disabled and who has demonstrated interest in citizen access and participation in local government. Prop G removed disabled and replaced that with physically handicapped. So that was the only change to that sentence from Prop G in 1999. I didn't go back to look at if that was an original provision from 1993, but I recall that that was an important consideration in the composition of the task force in the 1990s because I don't think the Mayor's Disability Council had yet been established, and so there wasn't a citywide body or some way to advocate in an organized fashion for the interests of the disabled as relates to public meetings and records. Because the Youth Commission had already been established, there was no designated seat for a youth member on this task force, either originally or in the Prop G amendments. The language of 67.30 as it currently exists says there's hereby established a task force consisting of 11 voted members appointed by the Board of Supervisors, et cetera, et cetera. Certain members shall be appointed, et cetera, et cetera. And at all times, the task force shall include at least one member, as we said. All of those requirements are being adhered to, and were always adhered to. The vacancy notice and the content of the vacancy notice was triggered, I guess, because of the MADI Act requirements and state law 54974 government code. The content of the vacancy notice is pretty standard and includes language about specific seats and general requirements applying to the body. So I think that language is okay, and we certainly don't control the language of the vacancy notice. The rules agenda, I think, reasonably describes the action before the body. It was a hearing to consider appointing members to the task force for terms ending various dates, and describes the seats and who was sitting in them and the requirements for each seat. How the Board of Supervisors operates to fill vacancies on this body, how it makes appointments generally, how it goes about its legislative business is really beyond the scope of this task force. So long as the members are appointed pursuant to law, I think we're good. And just finally, as to Member Oka, he's served as a holdover since April 27th, 2013 for over a year and a half, and yet he's still an active voting member. I believe Member Washburn was never appointed during the 2012 term and served as a holdover for that entire 2-year period, right? So, and Member Nee as well, and yet continued to serve as an active member, et cetera, et cetera. So, in summary, I don't think there's been any violation here. I understand there are concerns about the makeup of the task force, the way the Board of Supervisors goes about its business, all of that, and people are free to contact supervisors about how they do their thing, but I don't see that there's a violation of the ordinance, and certainly not anything that this body could adjudicate or remedy in any way. So that's where I am. Thanks.
Member Rummold.
I would like to emphasize that I agree entirely with what Member Pilpel just said. I think it's way outside the scope of what we do to say that particular votes should be held on particular days, especially when there already was, the disability requirement was already being satisfied. I think it's just, that's like a political question, right? If the public doesn't like the fact that the Sunshine Ordinance Task Force is not meeting, they will let the Board of Supervisors know, and they will let the Rules Committee know, and that it's not our task is to decide public records issues, not to decide when the Board of Supervisors should hold votes on our appointments. And I think it's very, very bad policy to start weighing into that. And beyond bad policy, I don't think we even have the authority in the law to do it.
I wanted to say that our purview is wider than public records. We also have a lot to say about public meetings and agendas, and also about all the various articles of the ordinance, including the makeup of our body. So, members, any further questions of either the complainant or the respondents? Okay, at this time, the respondents, you have 3 minutes each to offer any additional remarks or rebuttal to what you've heard.
Thanks again for having us today. I just wanted to reiterate that Like you said, we don't think that these complaints are with merit. And I also want to clarify that we never denied applicant Bruce Wolf from applying. His application is still active because we haven't seated member Oka's seat. And since this complaint has even come through, we actually have 3 applicants for the seat. So we are actively recruiting. We do take this duty very seriously. So I just want to reiterate that, we did not deny any seats that day. And that's it.
Thank you. The representative from Supervisor Tang's office.
And just to add one more clarifying point, it was asked during the May 20th Board of Supervisors meeting with regards to the holdover status. It was actually asked repeatedly, so it was requested, and we did look into it. So it wasn't something that was just assumed or carried over. So thank you.
Thank you. The complainant now has 3 minutes.
I just want to repeat that this is about the May 15th Rules Committee meeting, not May 20th, not June 5th. And also, this is not about asking them to take a vote. The issue here is that the supervisors took no action to ensure that that requirement was met or to even discuss it. It wasn't discussed at that May 15th meeting. And it was not in any way, shape, or form addressed. And the urgency of that should be foremost on this body because they couldn't meet for 2 or 3 months. And I know you haven't been on this task force for very long, but you'll find that in about 6 months from now, the supervisors will start to say that it was your fault. And that is what this is about. They will start to say that you guys cannot keep up with what is going on. So I'm not saying they had to vote on it that day. I'm saying they didn't address it, even though this board had been hindered from meeting. And that is what is important about them addressing it. And they are that part of the Sunshine Ordinance is particular to the Board of Supervisors. They're the only ones that can make those appointments. So nobody else could violate that one except the Board of Supervisors. They're the ones that are required to make sure those appointments are made. You need to make it's not just a political statement, it's a statement about what the requirements of the Sunshine, and there were other violations that they had made by the holdovers, covered by the holdovers for these, statements about the 2 SPJ seats, but they addressed that. They talked about it. So it was out there in the public for the public to talk about, but they didn't even talk about the disability requirement, even though this task force had not been able to meet. They're the only ones that can fulfill that. That's particular to them. That 67.30 is only on them. That rests on their heads. They're the only ones that can fill that particular part of the ordinance. Nobody else can do it. They didn't have to vote on it, but they didn't even discuss it. And once more, they can mention it at the Board of Supervisors meeting, but the public doesn't have an opportunity to talk about it. And I'll repeat to you that the vacancy notice is not the agenda. Why should they be able to list every single requirement merely because they randomly assigned a number to your seat, except that one requirement on the agenda? What will they leave off of the other commission's agendas if they feel like it? There was no reason that should be left on the vacancy notice, and contacting the Office of Disability is not a part of the agenda.
Thank you. The matter is now with the task force. Is there a motion?
Take public comment, then.
Well, let's take, I'd be interested to hear from the public on this one.
Thank you, Chair Washburn. Patrick Minette-Shaw. My recollection is that although Member Oka has served admirably as a holdover, he had not applied on May 15th. I believe his application was dated June 4th. before the Rules Committee. My recollection is also that Deputy City Attorney John Givner had advised the Board of Soups, and I'm fuzzy on this, possibly on May 20th, that the holdover rule does not apply to the task force. You guys need to research this. I think there was some concern exchanged among sunshine advocates in town. And the question was, if the holdover rule doesn't apply to the task force, Patrick, do you want to see member Nee and member Washburn removed? And of course I didn't. But if the holdover rule does not apply, the Board of Soups can't just presume that they have a disabled member in their hip pocket and that they don't even need to discuss it. They just guessed that Mr. Oka would agree to be a holdover appointment in light of the evidence that Mr. Oka was desperately sending emails asking to be removed, which has not been, officially made a public record. But Supervisor David Chu has released some of those email exchanges in which Member Oka had been begging to be replaced. Finally, you need to support the complainant's allegation that the agenda itself was deficient. The agenda, which falls under your jurisdiction, did not say one word about the disability requirement. And it can't be an attachment to the agenda. You have ruled as a body over and over and over that agenda requirements have to be on the agenda. And it has to be in plain, clearly understandable English. There was nothing on the agenda to even mention it. So at minimum, you need to find the strength to introduce a motion tonight saying that if nothing else, the agenda had in fact been deficient.
Task Force member is Richard Nee, a former Task Force member. If I can inform the discussion a little bit, my understanding is that the policy is that unless a member of the task force or perhaps another body formally submits a resignation, the person is considered to remain on that body after the person's term expires unless the person is replaced. That was certainly the case with myself and Chair Washburn. It was the case with member Suzanne Manet until she was forced to resign due to heavy academic and professional workloads. Member Oka may have asked Board President Chu to replace him. However, my understanding is that Member Oka did not submit a formal resignation, and therefore his status as a holdover was valid and in effect. And I think that is the default policy. Whether it's a good one or not, well, we can argue that till kingdom come. But I think in this case, what you have before you is fairly clear.
Thank you. Is there additional public comment on this item?
Thomas Piccarello. Everybody in this room would strongly agree of the culture of hostility by the Board of Supervisors toward the Sunshine Ordinance, not only the task force, but the ordinance itself. Having said that, the remedy there is at the ballot box and not this task force. It's not your role to tell supervisors how to act politically. None of us liked the delay by the Board of Supervisors, but you have no jurisdiction on that issue. It's true. You have no jurisdiction. So I suggest to the complainant that she organize politically and remove some of the supervisors who have this great hostility towards Sunshine. Secondly, when the task force went into a hiatus status for 4 or 5 months, that was self-inflicted in the sense that you really didn't get a clear-cut opinion by the city attorney that you couldn't meet. You did not meet out of abundance of caution. That was your rationale. But the city attorney never told you couldn't meet. And I believe you could have met those meetings without the disabled member. Thank you.
Thank you. Is there additional public comment on this matter? Seeing none, the matter's back with the task force. Is there a motion? Members?
Seeing no motion, the matter is concluded.
Member David?
Can we take a 5-minute break?
Sure, yeah. I was just in the rhythm of it, asking them things. No, it's fine for us to talk amongst ourselves.
I'll give you a topic. The Holy Roman Empire was neither holy nor Roman nor an empire. Discuss.
Discuss amongst yourselves, yeah. The September 3rd, 2014 regular meeting of the Sunshine Ordinance Task Force is called back into session at 8:23. I'm wondering if we could juggle the remainder of the agenda a bit and move item number 9 up and hear that right now, because it's going to be a continuance, but we want to give the member or the representatives from the police department just a chance to say something. She'll give us some written.
Don't we have the person from the civil service? It's civil service. Yeah, that's
Yes.
the person.
Mike.
I'm sorry. Whoops. Where are we?
Yes, she's from the Civil Service Commission.
I thought we heard this earlier, and
Yeah, that's who I'm.
I screwed my numbers up.
It's civil service. I'm sorry. Yeah.
she is still here.
Yes, and I would like to hear.
I went dyslexic on the numbers. I take out.
And I got the agent. It's late. Okay, so item number 9.
Item 9, file number 14080, hearing, peace officer confidentiality.
So we're actually going to discuss this further at a later meeting, but we understand you're leaving your post, and we wanted to give you an opportunity to discuss this matter, and then we understand you'll provide us with a written statement. Okay. Thank you. If you could reintroduce yourself to us.
Sure. Jennifer Johnston, Executive Director on behalf of the Civil Service Commission. I wanted to thank the task force, number one, for moving our item up. It is late, and you certainly have sat through a very long proceeding this evening, so I appreciate your time. I also appreciate the opportunity to speak to, I frankly remain a little confused as to the purpose of the opinion and what import it has and how it applies in this case. It does seem to me as though, and very well written, by the way. I don't know who the author is or when it was written, but really, I was very impressed, of course, as I should be, but I remain confused as to its import with respect to the Civil Service Commission's procedures. So I did want to just outline, while we agree with the findings, we do have disagreement with respect to some of the comments about the Commission's procedures that I would like to address if that's possible. Okay.
Yes, please.
Okay, so I certainly won't belabor any of the points, and again, I appreciate that that at least the draft opinion agrees that, or concurs the commission didn't violate the Sunshine Ordinance. But I did want to correct some points. So first of all, on page 425, the opinion correctly notes that the Sunshine Ordinance and the Brown Act allow a policy body to hold closed session hearings to hear complaints or charges against an employee unless the employee complained about requests a public hearing. Where we disagree, however, is that the opinion concludes that because Inspector Lee requested a public hearing, therefore it no longer fell under the permissive meeting body provision under the Sunshine Ordinance Task Force, the Sunshine Ordinance and Brown Act. The complaints, he was the one who was making complaints against other people. He was not the person against whom complaints were made, and therefore it still, in fact, did meet the permissive topic exception under the Sunshine Ordinance. So if it had been the police officers against whom he was alleging the complaints were the ones who requested a public hearing, then we absolutely agree that the permissive topic under the Sunshine Ordinance would not have applied. But in this case, he was the one making complaints against other people. Second, although the author agrees the commission did not violate the ordinance, the author believes the commission's procedures concerning peace officer hearings are deficient and urges the commission to re-examine them. We obviously very strongly disagree with that. Contrary to what the belief is, it is not the case the commission believes that the case law allows us to have a blanket of secrecy. We don't assert that there must necessarily always be closed session hearings. In fact, our procedures provide for a very careful case-by-case analysis to make a determination as to whether it could be held in open or even partially open session. The opinion also states the commission could have done a better job of navigating the patchwork. We agree it's a labyrinth of applicable laws and competing interests, but it does not say how precisely, other than I believe to assume that we didn't follow our procedures in doing that case-by-case analysis, which we absolutely did. Given the specific circumstances of Inspector Lee's appeals and following careful review of his discrimination complaints, we made a determination there was absolutely no way to ensure compliance with penal code protections that applied in that matter. And that's because the fundamental issue that the commission was reviewing were those complaints against the peace officers. Did those officers engage in misconduct? And did that constitute unlawful discrimination or retaliation? It wasn't a tangential issue, and it could not have been separated out from any other issues under the commission's determination. And frankly, it would have been impractical and impossible to censor Inspector Lee or any other witness called to testify with any guarantee that they would not identify in an open session hearing the peace officers who were alleged to have engaged in misconduct. And in fact, he proved that point during the last task force meeting when he identified the officers against whom he was alleged the complaint. So proved my point in that. Fourth, the author believes that the commission is required to implement more robust procedures designed to hold portions of the hearing in public, that closed session proceedings may only be held in very limited circumstances, and that when there is a closed session hearing, that we must have transcripts and they must be redacted and provided to the public. Again, we very strongly disagree with all of those findings. I think the fundamental crux of the issue is that the author disagrees with the courts and with the provisions of the Sunshine Ordinance and the legislature and the voters in their wisdom. The opinion concedes the task force and the commission are bound by case law, but disagrees with the court on the basis that there's no per se explicit statutory prohibition on public hearings of peace officers. We disagree that silence means ambiguity in any statutory construct, and the legislature in its wisdom has not chosen to overturn the courts or to enact any other laws that would be contrary to those legal findings. And it does make sense that to have an open session on a confidential matter, it doesn't make sense. You'd be, in essence, it's a Hobson's choice. People come before you. If it's going to be an open session, you're thereby ipso facto having an open hearing on a confidential matter. So I think that the reasoning of the court does make sense. And again, the legislative branch and the voters of San Francisco, in their wisdom, agreed or disagree with the author. The ordinance specifically allows for closed session proceedings in circumstances like when you're reviewing complaints against an individual or an employee, not just when deemed absolutely necessary under state law or under the law. And nowhere does it state that such proceedings must be transcribed, redacted, and made available to the public. And in fact, the Sunshine Ordinance pages and pages of provisions very specific to closed session procedures, what's required with respect to audio recordings, the minutes, the notice. Nowhere in there does it say that we have to transcribe the closed session proceedings, find a way to figure out how to dip in and out of closed session hearings on those portions that may be heard in open session, and then transcribe and redact the records. We, like you, don't have transcribed recordings. They're not televised. They are audio recorded, and by that, in that respect, we do meet the requirements under the Sunshine Ordinance. So in imposing such requirements, I also want to be very, I want to note that in so holding that any closed session proceeding has to follow those requirements, you're saying that any closed session proceeding held by any policy body must be transcribed, redacted, made available to the public, and again, that's not the case under the Sunshine Ordinance. So I thank you very much for your time, and I do respectfully request, strongly request, that the urging of the Commission to revisit its procedures, or the implication that we didn't follow the procedures in reviewing Inspector Lee's matter, be amended or revised from the opinion. Thank you. Do you have any questions? I talk very quickly. Sorry.
Member Pilkington.
You're going to follow up with something in writing capturing all that?
I am, and I believe the Police Officer Association and the Police Department also. And I think to the extent that this opinion may impact other commissions, I think there are significant other numbers of parties of interest who may want to submit something in response. I don't again know what the import of this opinion has, but.
Well, we can talk about that now and in the future. Okay. If you're reaching out to various folks, might you talk to the Police Commission and the Fire Commission? Because I think they're the only other bodies that actually might hear employee matters before the Commission.
If it's your wish that I do so, I don't feel that I should be advocating, but I can reach out to commissions.
But you talk to them, and, you know, I mean, this doesn't really apply to Rec Park or MTA because they don't hear employee complaints in the same way. It's really only those three commissions that do.
Or closed session proceedings, I don't know.
Well, all the bodies have potential closed sessions, but not really related to personnel except for the department head that they hire and may fire. It's mostly litigation, real estate, and that sort of thing.
Oh, it's unclear to me that this was just limited only to complaints against employees, but I thought it was just all closed. It seemed to... So, well, sure.
So the other thing that I wanted to say to the task force members, I think regardless of where we go with this opinion and whatever import it has, I think for me that there are two issues in reviewing the ordinance that we want to think about. And one is employee misconduct and how much information about allegations of misconduct, confirmed misconduct, should be made public, whether it's peace officers or any employee. You know, if you allege that somebody stole 20 cents from the treasurer's office, you know, should that be public because you made the allegation, or should it be public if it's confirmed? You know, how much should be available about allegations about employee misconduct? And that applies to, you know, department heads, mid-level people, bus drivers, anybody. That's one. And two is closed sessions. What information should be I'm assuming the closed sessions are confidential, but what required disclosures should there be? In some cases, should a redacted transcript be required? Or are there other things that should be made known out of a closed session that aren't currently required disclosures under 67.12? So for me, those are things to think about. We can't, you know, change the law right now, as, you know, Vice Chair Hyland understands, but there are things that we want to think about in the future. This, you know, we talk a lot about fixing the law. We should actually do that, you know, one of these years, and recommend that to the board and to the voters.
Okay, thank you. Member Wolf?
It seemed like you had some questions about what the role of this opinion is, and as best I understand it at this point, it's Member Rummel's opinion, and I don't know whether we have plans to adopt this as a task force. Is that in front of us tonight to adopt this opinion? Okay. So I just wanted to speak to the fact that it's Member Rummel's opinion and not the opinion of the task force necessarily.
Very well written, but yeah, I'm not with everything.
And we requested this, and he graciously offered to provide it. And so are just trying to understand these issues better before we go back to the case. Member Rummold.
If I could, I was curious to hear why you think it would be impossible to hold some type of like hybrid private-public. Because, and I'll stop you before you even start, in court proceedings, there are obviously,
in camera?
In cases like sexual assault or something like that, there are oftentimes, provisions that are made to maintain confidentiality of people testifying, but without disclosing their identity. And, obviously, I'm not saying that, all those types of procedures need to be employed, but why there isn't some possibility of making some information about the complaint public without revealing the two things that I think are protected, identity and, basically the specific identity of officers tied to specific facts.
I don't think that's always going to necessarily be the case. I think that you can have some proceedings or some portions of it if the issues can be bifurcated and separated. In this particular instance, that would not have been possible. It was all very intrinsically tied to who they were, what they were alleged to have done. It was very obvious the identities of the persons. I mean, we could have redacted everything but the and, but for maybe a few howevers, but it would have been impossible to have it in open session. In this particular case, I'm not saying that it's always got to be the case, but in this particular proceeding, there was no way to ensure that the commission would be able to comply with penal code requirements.
Well, what about this particular complaint made it that way? And that, say, the next complaint against an officer wouldn't also fall within exactly, I'm not asking for specific facts about this complaint, but I'm talking, what were the types of facts that made it such that those facts would absolutely identify an officer and they wouldn't also be present in every other case involving a complaint against an officer?
I don't know that I can get into specifics without disclosing as much information about who the individuals are. Maybe we could have like a side conversation or something, but I don't feel...
the
individuals
don't want any
involved,
information about
the individuals involved, it would have disclosing where they were in terms of reporting relationships, where they were in the department, stuff that they did, you would have been able to figure out who was alleged to have done what. And Inspector Lee also did not... as during the last task force meeting, he could not help but want to disclose who the officers were that he alleged to have engaged in unlawful misconduct in that particular matter. But there are matters where we have peace officer proceedings that have, that entail confidential records that we can have an open session, or partially open session to the extent that we're not disclosing that information. But so the issues here could not have been separated out from the question of whether or not the specific misconduct. It's difficult for me to say without you having reviewed the files, but I can tell you that I can contemplate instances where it's not necessarily a peace officer who's being accused of misconduct, but a peace officer who's making an allegation. We could potentially try to have some of that session an open session, or if it's a matter of whether or not a peace officer meets minimum qualifications for to participate in an examination, we could hold some of that proceeding in an open session. I believe that we could, but it would depend on the facts and the circumstances of the case.
Well, so that was, I think maybe you took the thrust of what I was saying maybe a little too to heart. I was only suggesting that there may be circumstances in the future where better procedures could be designed to ensure that a case like what you just described had partially public proceedings and
Yeah,
partially.
our policy does provide for that, and it is on a case-by-case basis. Maybe, it wasn't that clear as it's articulated. We also have internal protocols, but the procedures do require that I do a case-by-case analysis to be reviewed by the commission when they determine whether or not to go into closed session. Yeah.
Member Pilpel, and then we need to move on.
Yeah. So actually, the task force may be interested to know that the current city attorney assigned to the Civil Service Commission is the same one assigned to Rec Park. So we'll hear about that in a few minutes. Never mind. I actually think that we should, not tonight, but soon, adopt some version of this, perhaps as modified, to reflect our views on the matter and conclude the other underlying hearing, the Frank Lee matter, and communicate it, somewhat broadly in city government and have a bit more of this dialogue. I think this is a good dialogue, but I think to sort of broaden it to other commissions, the mayor, the board, the city attorney, on kind of this question of how much openness do we want, understanding to some extent what the law currently requires, but sort of what do the people kind of expect here, whether it's a police officer or not a police officer. I really think that this is kind of an interesting, colorable issue. Perhaps, and we haven't looked at the Civil Service Commission's annual report. Perhaps in your annual report, which I'm sure you've written and will or whatever, you could indicate the number of times you've had to hold a closed or a semi-closed session because of peace officer confidentiality issues. I mean, there may be ways that you can say, and how you sort of dealt, not you, your success, various people had to deal with the issue. And how you made those choices. If there's a circumstance where there are like 3 officers involved, one who's making allegations and the other 2 who are on the other side, right? If you can refer to Officer 1, Sergeant 2, and Officer 3, right? And even if you provide a confidential memo to the commission identifying who those individuals are, but say in the public session, we need you to just refer to them by number, and the point is, when you get creative, there may be ways. And as long as we're mindful that as much of the public's business that can be done in open session should be, and we should reserve closed sessions to only those things that absolutely have to be, because there's no other way without, giving away what our litigation strategy is or whatever, which you get. All right, anyway.
Thank you.
Thanks.
We do report on closed sessions, and we have a full appeal log of complaints filed that they just refer to the officer by, or whomever by number, but we do report on all that information. So,
thank you. Thank you so much for your patience and for coming tonight.
You need a motion to continue this to the call of the chair?
Yes, we do. So, do I hear a motion?
Motion to move this to the call of the chair.
Second.
Can that be with the understanding that next time it'll be paired back with the...
Right, we do need to hear the case that was continued.
Right. So is that with that understanding?
Yes, I think we can do them concurrently or sequentially on one night. Is there any public comment on this matter? Okay, seeing none. What you call the...
I'm sorry, I don't mean to wear out my welcome. I will no longer be at the end of this month. I wonder if you have a sense as to when it'll get scheduled, or, and if not, that's okay. I was just wondering to plan my schedule myself.
You got to send us your memo first.
I will do that post haste.
Okay, probably not until October. Yeah, we have the agenda.
Okay, of course. Thank you very much.
Okay, best wishes.
You can always come back. You won't be that far away.
Mr. Young, could you?
On the motion to continue to the call of the chair, Member Rummel?
Or without objection?
Or without objection? Okay, without objection. All right.
Item number 7?
Sure.
All right, this item...
Items...
Okay, I'm sorry.
Sorry. Item number 7, consideration of the Ethics Commission's referral to the Sunshine Ordinance Task Force regarding Sunshine Ordinance Task Force file number 12058, Mayanki versus the Recreation and Parks Department. You do have a letter before you from the, I believe, Mr. Ginsburg.
All right, and there was a request from Rec and Park for a continuance of this item. And I wanted to say that I think it's very important. I urge everyone, I plead for everyone to listen to the recording, or it's a video actually, of the May 5th, no, what date was April 28th Ethics Commission meeting. This matter lasted about 2.5 hours. It's important for many reasons. It is one of the only times that the ethics commissioners have actually discussed one of our matters that we've referred to them. So it's momentous for that reason alone. And it looked to me that they were agreeing with our determination that there was a violation. It took them a while to get there. But there was an issue about whether we had properly named the department chair, Phil Ginsburg. Certainly we had not named him, or he was not named early on. We hadn't heard the case. We often don't know exactly who to name in a violation. So that was why it was sent back to us to rethink that part of this, not to re-adjudicate the finding of a violation, but to properly, as they said, name someone. And when the issue was whether or not the person we named, Department Chair Ginsburg, was properly noticed. We can argue that he was. He was certainly noticed of our hearings. We had multiple hearings. And he hinted as much in his letter to us dated today that he was aware of this matter for quite a while. Member David.
Yeah, so I mean, I've been the lone nay vote on this issue all along, but my question is that why do we need to defer? I mean, it seems like what we need to move it forward, we need to clearly name Phil Ginsburg as the respondent, or I'm not sure what it doesn't seem like. It seemed when I read the letter, he's making the exact same argument that Ms. Gong made, that he felt that the records were redacted, were redacted correctly. I happen to agree. I was the one person in the minority, but the rest of the task force voted to move it on to ethics. So I guess I'm just confused as to why we don't just name Mr. Ginsburg. Like, what's the purpose of?
We did name Mr. Ginsburg, and the Ethics Commission said, perhaps you got it wrong. Perhaps he wasn't. Because Member Pilpil was at the Ethics Commission meeting and brought up this issue that perhaps the task force got it wrong when we named the department head, Ginsburg, as the responsible party here. And this is relevant to another matter that's been brought regarding Member Pilpil appearing to represent us before the Ethics Commission and speaking contrary to what we had determined. So at any rate, I really need for everybody to watch this. I think because here's an opportunity for us to work with the Ethics Commission to, make a decision about an important issue. This is a really important one. This has to do with privacy, and it's privacy versus the public's right to know what their government is doing. And so those are the two issues there. And the issue's interesting, and this is momentous because they're finally taking us seriously. They actually ended up agreeing with us. So, but they said we can't find a unwillful violation because we named Phil Ginsburg, and perhaps we did that incorrectly. So Vice Chair
Through the chair.
Vice Chair Hyland.
Who are they suggesting we should have named?
They weren't suggesting anyone. They need for us to, one thing we can do is go back and review what we did over at least 3 meetings. Find out, did we notice Phil Ginsburg about, after we referred it back to the full task force? I believe we did.
For at least one meeting, I did find an email noticing Mr. Ginsburg of the meeting.
Right, and so the issue is whether there was due process. Okay, and there was argument about that because, due process is an issue when someone's property or someone's livelihood or someone's person is in jeopardy. But if it's just their reputation, then this becomes less important. So that was an issue. It's just fascinating to listen to. So please take the time to listen to this. It's very important to the work we've been doing. Okay. We have been struggling for, 15 years to get the Ethics Commission to listen to something. We went, remember, Nee and I and other members, Johnson, we met with the Ethics Commission. We worked on this jointly to try to get them to hear our complaints, and here they go. And let's work together to get this right. But I really need for you to get up to speed on this. You weren't here, most of you. Member Wolf.
So I just want to verify that Phil Ginsburg is unequivocally the head of Parks and Rec. There isn't like another latitude position or something. Okay, great.
Right. Vice Chair Hyland.
And it would be very helpful if you have it, but if you don't, that's okay, is the minute references to the parts of that 2.5 hour.
I can send them to you.
It starts around 4 minutes into the hearing. It's the bulk of the hearing.
Okay, so basically listen to the whole thing. Okay.
Right.
I mean, just from my recollection of those cases, I remember, I'm pretty sure we found them in violation of 21E, not sending someone knowledgeable, and I don't know if that constitutes, notice, but I remember being very frustrated with Ms. Gong because she really just didn't have the tools to answer our questions. And, I think our position was, and probably still should be, the buck stops at the head of department. So I guess we have to go and listen to that and maybe with the clerk's help find out any and all instances where we noticed, invited, notified a more responsible party to show up and meet with us, which never happened, if I remember.
It never happened. And so that whole issue was also brought up, too, about, so who would you name in a case like this?
Default is head of department, isn't it?
That's what the ethics commissioners thought, too. It made sense to name him. So did we notice him properly? And did he receive due process? Although then they said in this case that was a moot. That wasn't necessary. But we did notice him. That's the thing. And he was aware of this case. He said he was. He knew about this. Yeah. So it wasn't like he goes, oh my gosh. And he was asked to come to the Ethics Commission. He didn't show up. He had another commitment. But please listen. It's actually the lawyers here in particular. Everybody will learn a lot.
Just ask a question. Can we just jump the gun and notice him now? I mean, is it past that point, or it'd be nice for him not to be able to dodge it any longer.
I think we need to put this on the agenda, and he should be here. Although we can't rehear this thing. This is the thing. We're not going to re-adjudicate it. I mean, nothing's changed. Okay. But
just thinking of where this might go.
Yeah,
If we all get up to speed on it and we discuss on the agenda, and then we respond to the Ethics Commission saying that we think we did this, and this, and bounce it back to them. Is that a possible?
I think maybe we need to, rather than have Phil Ginsburg's written us a 2-page letter that he just gave us tonight, but I think we should. I think we need to get up to speed. We need to talk about it again, and then we have to figure out what to do. But we can put this. put this on the agenda for the next time. Let Rec and Park know it's on the agenda. Okay. Homework. Yes.
At the discretion of the chair.
Excuse me. I want to hear from the other members. And Member Pilpil.
So there's a lot that I could say, and I want to be somewhat careful about what I say on this. My conduct notwithstanding, on the merits of the issue, I think that we have pretty much colors and flavors of three choices. One is to notice it again with an intent to send it back to ethics, kind of clean up whatever notice issues. I think have a more detailed referral that explains the thing a little better, and get it back to ethics, naming one or more people over there. I think it could be up to 3 people. It could be Phil Ginsburg, Olive Gong, or Sarah Ballard, because she actually was at the Ethics Commission meeting representing Phil Ginsburg. That's one. 2 is to work out some kind of arrangement with the department where they would either finally provide the unredacted documents, which they should have done a long time ago, and the thing goes away. I think that's unlikely because it appears from the letter that they're, not changing their mind, and I don't think we should change our mind. And the third is to just drop the thing, which I'm also not in favor of. So I think that if we're going to do a job with this, we should put it back on the agenda and invite both the department, whoever they send, and Mr. Maionchi, and have some further discussion with him, perhaps, and send it back. I would note that although the facts were somewhat different with the Micah Ringel case that went over to ethics, they found a violation by John Ram and said that he was ultimately responsible with that, the buck stops with the department head theory, which surprised me because I thought it was possibly weaker in terms of the Ram case. I thought, but whatever. So I don't think they're against making a finding that a department head violated the ordinance. I think that there's a good argument here. I think I'm just not sure that we conveyed that as well as we could have. And if we do that and do a better job, I think that there's a pretty good chance that this thing will pass at ethics.
So the Micah Ringel case that was heard after this one?
Yes.
Okay. What date was that?
That was July 20, whatever.
Okay. So it could be that they were influenced by this case.
Yeah.
In which case, this may. So we might as well invite Rec and Park and Mr. Maionchi to come. He needs to get that information that we said he...
And I had drafted up a 2-page thing, and I'm happy to bring that back with some more background on the case that I thought would be helpful for the referral, but the referral letter that former Chair Grant sent didn't include that. And I think that that's something that we could do better. We do a great job of sending over a big pile of paper and saying you can watch all these meetings, but we don't really tell the story. Mm-hmm. And if the referral letter tells the story better, and there really is a good faith dispute here between us on the task force and the department and the city attorney about whether disclosure is warranted. And they talked at the Ethics Commission about sort of the risks on both sides. If you disclose, the people whose info you're disclosing may get pissed, and if you don't disclose, we and the complainant get pissed. So, but that's the balancing act that has to happen here.
In the end, what was dispositive here was the fact that this information that the complainant was asking for was pertinent to the operation of the government in this case. And that was what we had decided. It took us a while to get there, but we decided that. And that was what they decided. And when I heard...
It wasn't the unanimous view of the commission, but it was the majority view.
We don't really know. We didn't hear from a number of them, and the vote was kind of weird because of this naming issue, which was brought up. So, Member Davis.
I just want to make sure, so I might understand that what we're going to do is we're going to move this on to another agenda in the future, and we're going to invite the parties back. Is that what we're doing?
Right.
Okay, perfect.
And then we're going to send this back to, Ethics is expecting to hear back from us.
Okay.
Okay?
So the agenda should be clear that that's our intent, so it's not just
Yes,
another...
we understand that. And if you have anything you want to send that would help us tell the story better, that would be if you would send it through the Victor.
And only to Victor.
And only to Victor, right?
Joking.
Okay. So...
Through the chair, public comment on this item?
Yes, absolutely. Is there anything else? Okay. Do I need a motion to continue? Okay. All right. So,
If you want to continue this item, yes, we would need a motion to continue.
Motion to continue to the call of the chair.
Second.
Oh, good. Then I can speak on the
yes,
motion.
you may. Yes.
Why, thank you, Chair
Okay.
Washburn. So as you're reviewing the April 28th video that's posted on the Ethics Commission website, you should also take a look at the July 28th video on the Ethics Commission website. April 28th, they discussed the Mayonchi case. July 28th, they discussed the Rangel case. And at the very end of the July 28th audio tape, or MP3 or video, Ethics Commissioner Keene it pipes up during the agenda item for future meetings. And he remarks clearly on tape, well, maybe we punted the Mayonchi case in April inappropriately because they voted that Planning Director John Rahim had violated the ordinance because he was responsible for his subordinates. That was one of the issues in the Ginsburg case, whether he was responsible for his subordinates. And Commissioner Keene was saying, we got it wrong the first time, but at least, and he said this, at least we got it right now. So my recommendation to you is you don't need to invite Ginsburg or Mayonchi. What you need to do is to simply write a letter to the Ethics Commission and return this matter to them saying, look, folks, you can't have it both ways. You can't let Ginsburg off the hook over responsibility for his underlings, but you're going to hold Rahim responsible for the same violation? All you need to do is to send the referral back saying, look, you sent it to us for further factual information. The factual information is you guys can't have it both ways. You can't rule in one case for Rec and Park and in another case against planning. All you need to do is send it back to them saying you punted the case incorrectly. Go back and fix it because you can't have it both ways. That's what you need to do. You just simply need to send the case back. No more adjudication. No more excuses out of Ginsburg. No more excuses out of Olive Gong or Sarah Ballard. Just send it back to ethics. You made a mistake the first time. Now fix it.
Thank you. Vice Chair Hyland.
I was actually going to suggest exactly that option before we took our motion to continue. So do we still have that option based on how we tabled this?
Right, but I think you all still need to watch the video, and there are a number of issues here. And I'm going to watch the second one, but this is so important to what we've been doing for all these many years. And so I also think that we want to, if we send them a letter, which is, a good, clean way to go. It needs to be a punchy letter. It needs to.
I'll help you write
it. Hey, that would be fine.
I mean, I can see the value of having Mr. Ginsburg appear before us, or at least be invited to appear before us as further noticing
Yeah.
In that sense, that carries weight. But I'm also mindful of our backlog, and if this can be achieved with a nice, tight letter, I'm all for that as well, without the extra time on the agenda. That's just a thought.
Yeah, I think this warrants the extra time on the agenda, actually, and...
Okay.
Okay.
May I suggest that we have the letter prepared and placed as part of the packet for the next meeting? If that's something you would like to do?
Might be premature.
It might be premature, yeah.
The motion
Good
is the
idea.
call of the chair, so it gives you discretion. People should watch the thing. We'll try writing up a thing.
Yeah.
All right, just watch the two things.
Yeah.
Okay.
Thank you.
Thank you.
Without objection on the motion.
So, without objection? Okay. All right. Next item on the agenda.
Item number 8, Sunshine Ordinance Task Force Annual Report.
I'd like to thank Vice Chair Hyland in particular for his hard work on this. But it reflects a lot of people's work.
And actually, I'm sorry that former Chair Johnson's not here, because I used a lot of her template, I guess, to help craft this and kind of be a bit more inclusive. Basically, I just went into all the all the orders of determination that we put forward and made sure they were, reflected on it. That was the main change.
So, any comments? Member Pilpel?
I have some minor typos. How do you want to handle that? You want me to just read them in?
I think you have a PDF, so why don't you give them to Victor?
Item 8.
I don't have it. Well, I can get it as a PDF.
What
do you want?
Oh, you have a paper copy.
got a
Yeah,
paper
we'll
copy.
give him the paper copy.
I didn't mark it up yet,
Oh,
but
you
I
didn't
can.
mark it up. But make sure
I can certainly do that. There's nothing huge. I was in a consumer advocacy seat, not general public. It's Celia Lee, not Celia Long. There are a couple other things like that. I think it's fine the way the report lays out what happened. I mean, in practice, I don't know who's actually going to read this. I think we're just sort of going through the motions here. I think that's unfortunate. I think it would be good to put in a sentence saying that there was no annual report covering January through April of 2012, because we're just sort of picking up for that 2-year term, and the last report ended in December of 11.
Yeah, I think it reflects that we were dormant for that period. I believe it says.
No, the task force was active, but it was when it was the end of Hope's term, and there was. And so they did an annual report on an annual basis, and we're now going to a term basis, which is fine, but we should indicate that we're just not reporting on that period.
That's fair.
I also think it would be good, I think it's fine to copy the full board, the mayor, and Angela. It might be good to copy the city attorney, maybe even the ethics commission, I don't know. I don't want to make this like a Christmas tree of sending it to everybody, but I think that to the extent that we're trying to build relationships with those key actors, it might help. I mean, heck, for that matter, it might not be bad to send it to the grand jury. I don't know.
Sure. My members?
Those are just some thoughts I had.
Personally, but I wrote the original one. I think you overly sanitized it. I think you took out. That's right, we're taping this. I mean, you took out a lot of the points that Kit and I, that former Chair Grant and I had made, and you're go ahead. You're playing your audience. Knock yourselves out.
Members?
Well, I guess then to conclude, if I, and to Member Fisher, if I thought that the content of this report would influence much of anything in the world, I might fight about the content. Unfortunately, I just don't think it's going to matter that much.
Unfortunately, I have to agree with you, Member Pilpel.
Member David?
So at an earlier meeting, I think the first of this new group of task force members, the newest members on the board, I think expressed concern about approving minutes of events that they were not here for. So I'm wondering, before we even discuss the merits of this further, should we get a feel of if, whether this is Shakespearean or not, whether it would be approved one way or the other?
I'd like to have Victor talk about this issue. It's analogous to minutes and whether, if you weren't around, can the minutes still be approved?
Yes. Minutes are slightly different in that you can offer corrections to minutes, but you cannot vote no out of hand. There would need to be actual correction that you would like to propose. In most cases, that is what Robert Rules states on the minutes.
So this is.
Well, you can under the charter, and you did, and that's fine. So that's done. I think Member David's question is still germane. How do at least the 3 new members who are here tonight feel on voting on an annual report of any kind? It's a good question.
Vice Chair Hyland.
And just to, be clear for the newer members, part of the problem with this shorter original report was that it was not voted on by the rest of this committee. It was presented by the previous Vice Chair and Chair Grant to the Rules Committee as a, finished product that we all voted on. That was incorrect. So this is an opportunity to, that was correct.
It was
not voted on by us as an approved annual report for you guys to then present it. Let me, if I may finish.
Chair Washburn.
So that's why we're going through this again and doing this. And it was, it was an opportunity to make it a little more inclusive. So there was some work done to mention other cases that were, quite frankly, glossed over in the previous version. So I take exception that you characterize it as playing to the audience. There was a lot of hard work put into this, and we're doing this correctly, and that's why it's before us again. Thank you.
Member
Chair
Fisher?
Washburn, I have a problem with Vice Chair Hyland speaking authoritatively on something that I sense he knows nothing about. I was with Chair Grant at several meetings with the supervisors when we went through this annual report, and they asked her to come to the Rules Committee, which she did not want to do, but she did, to give a draft. It was not presented as something we voted on. You can go back and you can look at the tapes and everything. It was not presented. We had 3 conversations, actually, with Jen Lowe, who was here, about the annual report. We reviewed it with them and said this has not been voted on. This is purely a draft. And we were asked, would you, the 2 of you, please come? And thankfully, at the last minute, Kit said, I'll just do it myself. Can you present, the draft of what you have? Basically, it was, tell us a little bit about what happened. I mean, the words annual report did not even have to be used.
Thank you. Vice Chair Hyland.
In response to that, exactly what Kit presented was then put out as the draft, as the first draft.
Correct. It was a draft.
Which, again, was not voted on us, was not...
Not disputing that at all.
We didn't agree upon that to be presented and representative of the body. That's the irregularity that I'm pointing out. Anyway, we're past that. We're here. It's in front of us now.
Okay. It's Member Rummold.
As a new member, I would say if you could just add a sentence or something that says this is based on the experience of members of the task force who were appointed, at the time, right, and does not reflect new members' experiences. I would gladly vote anyway on it.
Okay. Member Hebner.
Yeah, I mean, I agree. I mean, have us approve it as to form. I would, I don't want my vote one way or the other to be a referendum on anybody's different feelings on the report as it exists right now or earlier, or any edits that have been made along the way. I wasn't there to witness it. But I would approve it as to form, or in the alternative, align in it as suggested by Member Rummold.
Member Wolf, you feel the same way?
I didn't volunteer to say anything right now. I have no issues with the way the document stands right now. I think Member Rummold's suggestion of adding that this represents the task force up to the period when this was started or whatnot makes sense. But I don't remember the previous draft, but this one seems to have less issues that are of complication.
Okay. So would it be possible for Vice Chair Hyland and Victor to incorporate the typos and this additional sentence right away?
How about something along the lines of this reflects the views of the members present during that 2-year period, something like that?
Or reflects the experience.
Experience.
Or the reports on the work of the task force during.
I mean, do we have to vote on it to approve it? Yes.
Yes, we do. We have to.
Okay.
Yeah.
And even so, do the new members still have to vote on it?
They do.
Regardless of the sentence? They do. Okay.
They do. Yeah.
Okay.
So I think a sentence very neutral saying that this reflects the work of the members during this time period.
The holdover members of the.
Right. Member David.
I don't want to get into much a parsing of words here, but I mean, let's be clear, like this reflects the experience of the author, because it was the experience of, I didn't have any problems with what Chair Grant wrote, and it was decided by other members that needed to be rewritten. So it just, I don't feel like that. I think, we're going to start getting into, we should move on, definitely, but let's be clear that this is the point of view of the author.
Actually, there were several authors that had input. I mean, it was.
Well, all of those authors, I'm just saying, I'm not saying a single author, I'm saying of the people who wrote it.
If I could answer that, I'd say 90% of this is the original draft. A few things were changed, and a few cases that we referred on were added. That really was the content. It's not so much views. It's not so much. I tried to make it very neutral, very non-political, very just factual reporting on what we did. I don't see where you're getting that direction from.
I wrote the section on compliance and amendments because I was the chair, and it's just an absolute plain vanilla straight reporting. And then Member Pilpel's report on the EOT is there. Member Wolf.
Like I said before, I don't remember the original version, but this feels much more of like an objective description than the other one did, as my memory recalls it.
Thank you for that endorsement.
Member Pilpel.
I'll take it at this point.
I, too, don't really want to belabor this much. Maybe so that we can all take another moment and cool a little bit on it. If we put it over one more time, incorporate the changes that we talked about. It sounds like there's an emerging consensus to approve a document, get it done. I think we could probably do that at that time. And, it reflects things. It doesn't reflect other things. You know what? It's a report. Reports are necessarily both objective and subjective. I mean, I don't really want to talk about it anymore. Do we need a motion to continue? I think it just needs a little bit more. It's very close.
How about a motion to approve as amended, including your typos?
So So who are we giving final editorial control to? You as the chair? I mean, that's the other thing. I think that the cover letter needs to come from you. You can certainly acknowledge Vice Chair Hyland. I think that's appropriate, but I think the transmittal letter really should come from you.
Okay, I missed that part. No.
That's right. That's what I was saying. And it refers to the administrator's report, which isn't attached, and things like that. So anyway, I have no problem approving it as to form, however you want to call it. You know, I think it's just going to take a little time, a couple of days, probably, to clean it up and get it out. I'm good with that. What do you want to do instead?
No, I think it needs more work.
All right. Well, then I'm back to continuing it.
I need a motion to do something or other with this report.
All right, I'll move to continue this again to the call of the chair so that you have discretion with the intent to try to do this at the next meeting if possible.
Second. We're putting in the typos, we're putting in that
typos, disclaimer, CCs.
And the cover letter.
Cover letter. Those are the things I got.
Everyone agreed on that?
All right.
I resume my second. It's still there.
Without objection.
Item number 10. There are no members of the public in the room. Item number 10, report, Education, Outreach, and Training Committee meeting. I believe that the next meeting shall occur next week on Monday. There are 2 items currently on the agenda. I don't believe there's any additional information at this time. Item number 11, report Compliance and Amendments Committee meeting. They met approximately 2 weeks ago. There were 2 complaints on the agenda that were concluded. However, we did receive letters from 2 of those complainants requesting that we reconsider it. I have addressed it in my administrator's report.
So,
do you have anything to state on concerning the meeting?
Yeah, briefly, I thought it was a really good meeting overall. It was my first time chairing the meeting, which is a little awkward because there's not a guidebook on how to do that. Nevertheless, there's a problem at compliance and amendments. There's a compulsion. There's sort of desire to re-adjudicate the underlying complaint, and it comes up when the respondent says, "Well, we looked and there was nothing," and the complainant says, "No, there must be something that exists," and then you have to go back through this whole process of determining whether there was compliance, whether a search took place. So we ran into that problem, particularly with respect to the complaint regarding the Arts Commission from Ms. Datesh, and it was sticky. It wasn't enjoyable at all. She wrote me a follow-up email that expressed her disdain for the procedure, to put it lightly. I was surprised to see her today. But that was, I understand where she's coming from, and it speaks to the sort of the ambiguity of some of the orders of determination we make when we're not certain that a record exists and yet we order that it be produced, or when we order something to be produced that the city attorney says cannot be produced. Then it goes to compliance and amendments and sort of perpetuates the conflict instead of actually reaching a resolution. And yet we reached a resolution as to both of those items, and that is sort of what it is. There was a great conversation with the city attorney about working together on, a meeting of minds as to what privilege logs may be produced under certain circumstances and what information can be included in that without divulging confidential information. I think that there is room to work with city attorney, the gentleman that was there. And that was a nice aspect of the hearing. Yeah, Gabe Zittrain, exactly. And that's my summary.
Chair Washburn?
Yes.
Yeah, there actually is a guide that I wrote last year for how to run a meeting. So did you not send that to the chairs of the...
No, I didn't.
I'm pulling it up right now.
Okay. Could you send it to...
I'll just send it to Victor.
Yeah, and then he'll send it to, yeah.
It's got reds and yellows and circles and where to
Okay,
go
yeah,
and
no,
what to do.
wasn't aware of that document, so.
Great, thank you.
Yeah.
Yep, here it is.
And when's the next meeting of compliance? It's not this month?
The third Tuesday bi-monthly, so it'll be in October.
Is that the one with the dates? No.
No, October 21st.
Got it. Okay. So then on the request for reconsideration,
May I get into the administrator's
do you
report?
want to deal with in that? Okay, fine. Cool.
Item 12, Administrator's Report. Concerning item number 2 of my Administrator's Report, I received a letter from D. Seligman concerning ADA accommodations in hearing rooms. He has a complaint concerning certain hearing rooms not having proper microphones. I do not believe that there's anything that task force can do to address this issue. That's a building maintenance issue. I have informed him, but if you would like to provide any kind of response to Mr. Seligman, I'd be happy to forward it. Item number 3, I have referred him to Rowan, but he is not satisfied. Item number 3, I have received 3 requests to reconsider decisions by the task force. However, pursuant to Section E of, I believe, our bylaws or procedures, reconsideration of task force findings, the only time that reconsideration can occur is within 10 days of receipt of an order of determination, either by the complainant or the respondent may do so within 10 days. There are no procedures concerning reconsideration of a committee meeting decision to conclude a matter, only concerning order of determination. This is something you may want to consider taking up during our Rules Committee meeting to see if there are any other opportunities you want to allow that, or to clarify that this is the only time that we may reconsider. I will be informing the complainants that we will not be able to reconsider this pursuant to our bylaws unless you have other instructions.
it's not the bylaws, it's the complaint procedures.
Yes.
Okay. Yeah, no, that's fine.
I have provided a list of the complaints filed within the last month. Under item number 4, I have item number 6, as requested at the last meeting, I have...
All right, on item 4, have those all been mediated, or it's not clear?
I do try to mediate all items, but I have not received responses yet.
So these are all still pending and they haven't gone away? Is that what
They
you're
have
saying?
They have not gone away.
Okay.
Does anonymous 2 mean it's different from the other anonymouses?
Yes, this anonymous, I believe, is...
The anonymi?
His complaint was done verbally, and it was incomplete. I will need to write him a letter stating what I need from him in order to process the complaint, and I don't think he will be able to provide that information. It was very vague and...
Him or her, just to keep him anonymous, right?
Yes.
Eric.
I had to process the complaint in one form, and so I created a file number for it. But I don't think it will go any further.
Okay.
At the last meeting, you requested I do an analysis of the pending complaints. Excluding anonymous, in 2012, at the time of the writing of this, we had 2 open files. One of them was the one we just heard concerning the Ethics Commission re-referral. We did have another one, 12055, that was continued to the call of the chair. They have finally withdrawn that complaint.
What was it? Do you recall?
It was against the city attorney, Woods versus the city attorney.
Okay.
All right.
In 2013, we have 3 open files. We have 2 Charles Pitts files, which is 13030 and 76. It was filed against a nonprofit, and I referred that complaint to the HSA. They have provided a response, and I have scheduled that response for a hearing before the task force.
Saw that on the agenda for the,
Yes.
right.
And then we have 13091, which was continued at the call of the chair pursuant to the police confidentiality report. That will be scheduled shortly. 2014, we have 21 open files excluding anonymous. We've heard 4 today. We will be hearing 4 of the 2014 files at our next meeting. And I would estimate we would complete our current files if we receive no new files by the end of November.
That's excluding anonymous.
Excluding anonymous.
Right, and so Victor and I have talked about meeting with her, talking with her about how we can help move these cases along, or what we can do. So I feel that there's some goodwill with her, and so that's our plan. Member Pelpel.
On that, and that's all to the good, actually. On the anonymous stuff that's still outstanding, do you know how many departments are involved? I assume it's planning, mayor, board of soups.
Majority of them are against the mayor and the board of supervisor members, but I have not analyzed that part of it.
I mean, if we cluster those like we've been doing, so there's
the
like
issue would be that anonymous tends to, after 1 or 2 cases, not be able to continue.
Yeah, I know. And we could either cluster or do 1 or 2 a meeting to let, however you can deal with it, whatever.
We are going to speak with her about this, so.
And I believe once we complete the complaint procedure that we were considering of sending items to the committees, some of those cases can be addressed in that fashion.
Mm-hmm. Yeah, that's one good idea.
I also wanted to ask concerning the September 23rd meeting, while the majority of the people are here, I wanted to ask who cannot make that meeting to see if we have a quorum or not.
So this is August 23rd?
September 23rd.
September 23rd, I'm sorry. So, which is not, so.
It's not a problem?
It is not.
Okay.
Erev Rosh Hashanah, September 20th, it's the 24th, so the 23rd.
I mean, there is an evening service that night, but
it's not the first night of Rosh Hashanah.
All right.
Then
we're good.
Are there any members who cannot attend on September 23rd? It is a Tuesday, I believe.
Victor, I'll let you know when I know. I'm supposed to go to trial on the 24th, but that may or may not happen.
Yes. I believe that we can proceed with the 23rd. It looks like we have a majority.
Okay.
The HSA files will be scheduled for that day.
Okay. Thank you.
Also on my issues, we do have approximately 25 sets of minutes prior to 2012 that I will be scheduling for October. I have pulled the procedures for processing minutes from the Roberts Rules of Order. I will distribute it to everyone via email.
Can I look at those minutes with Victor so as to minimize the amount of time that we spend on him here? Okay.
Feel free, and we must pass them.
Yeah, okay.
There's no more delay.
I haven't seen these yet, so I'll look.
It doesn't matter. We have to pass them. These are way old.
And we can always adjust them after they are passed if it's needed.
Okay, thank you.
The Government Audits and Oversight Committee will be meeting tentatively on September the 11th at 11 o'clock. They should finalize that by the end of the week. I believe that Vice Chair Hyland has agreed to present the civil grand jury report. And it has been brought to my attention that anything where we said requires further analysis, we will be required to provide that further analysis within 6 months.
Oops. I'm wondering, I'm going to be in San Diego for my work, but Member Hepner, you were so involved in preparing that, if you wanted to. Also,
Eager eyes are looking towards you. I would love to have him there.
yeah.
On
if you
September
could-
11th?
Yes.
Yeah, I can see what I can do.
Great.
11 a.m.
Once it's finalized, I'll send it to all members of the committee.
Okay.
Okay. That would be great, yeah.
That ends my administrator's report. Item 13, announcements, comments, questions, and future agenda items.
So I just have one question. When is our regularly scheduled meeting for November?
First Wednesday?
It's the first Wednesday, which I am.
So that would be the 5th,
Yes.
the day after Election Day. Fine.
Bring beverages.
Be in Washington. I'm going to have to
You're away for that?
I'll be at a conference for work.
So, Vice Chair Hyland.
Any other announcements?
So just a question. Let's see. EOT is meeting this month. Compliance is not. So the Rules Committee is meeting instead. So this will be the first meeting of the Rules Committee. Jack?
Yes.
And that's Tuesday, September 16th. Be here, be square? Okay. Good idea. No?
Member Rummel, then Chair Washburn.
Yeah, well, I'll still withhold decision.
So I
the
wanted,
bylaws require 2 votes.
So I wanted to present my bylaws memo and analysis of the bylaws. Can I do that through Victor and get that on the agenda for the 16th?
Concerning the Rules Committee, any documents will be accepted. That's pretty much what the Rules Committee has on their agenda, review of the bylaws and review of the procedures.
Okay, so I do plan to attend that meeting. I'm good. Thank you.
Is there
Motion to adjourn.
So moved.
You're adjourned.
Yeah, I just don't know how much.
They were
Much detail.
Yeah?
I think we're.
Yeah?
I think we're.